It was called for, but it has been listed for motion. So, and my friend has said that city is there in their office. Let the matter taken at 2 p.m. minus 5. 2 p.m. 1.
May I please understand? I know item number 48 the supplementary list. I have the instruction to close the case.
48.
48. Supplement. 48.
And the request to Mr. F.E. Borguia, London Council to the petition. Who submits that he has instructions not to press the bail petition further. The bail application stands dismissed as not pressed.
Like, may I please tell that?
Yes.
Might I dare to mention this matter for listing mind? This
What
matter
matter? What matter?
matter might have given a petition mind. Yes, ma'am.
Fresh matter?
Fresh matter, almost fresh matter. The notice issued matter, our house is confined in a particular area, by your passing an order matter. So it's a very urgent matter. Tomorrow, my friend.
Not tomorrow. It will come next week. Next week,
Tuesday, matter.
21st. 21st.
Obliged. May I please also? I take the election matter from data matter. The last case of listing matter was 31/3/2021 matter. But since then, matter, it has not been listed matter. So, matter, and next week, matter,
Not, let it come after vacation. What matter is this?
matter, single division fix.
Come after vacation.
Matter, kindly this matter, last. Next week.
For what? For admission.
Matter,
For admission.
hearing.
Hearing.
Since last 2 years, matter,
So last 2 years, you have suddenly decided to mention it now. 27 June.
matter.
27.
May I please also, my lord, I beg to mention, my lord, one IE, my lord, at 5113 for correction of your lordship's order. And only in condition number 4, my lord, Puliabo PS is given instead of Boripur PS. If possible, my lord, nothing today except my lord, because your lordship granted 10 days time.
Okay.
Obliged.
With the consent of the other side, I'd like to mention item number 40.
40?
Yes, sir.
Yes.
This matter may come after vacation. Due to some difficulty of my singing.
And the request of learned counsel hearing for the petitioner, respondent, have you taken consent of the petitioner?
Yes, sir.
Appearing for the respondent,
Be done.
he has submitted that the matter be adjourned for 2 weeks. It is further submitted that consent of the counsel for the petitioner has also been obtained. List after 2 weeks.
Your lordship, I pray for listing of an criminal petition, lordship.
Fresh matter
No lordship for orders.
or orders. It will come sometime next week. 23rd,
Next week, lordship on 28.
28th,
No, lordship 20.
20. 20. So many matters are fixed. Let it be on 23rd.
Lordship, I beg to mention for listing of one criminal petition, lordship. Let it be in the next week, any day.
Not next week. We for what? Admission hearing
For orders, lordship.
for orders. 23rd.
23rd of
23rd. Yes.
May I please, lordship? I like to mention one criminal appeal. It's an appeal against equity laws. May be listed on 21st or 22nd of this month.
No, it is a fresh matter or
No, not in the case, it's old matter, since there is no equity. Even in appeal against equity laws, party suffering law, 6 months,
22nd?
22nd, maybe.
22nd June.
I have given this matter.
Then list motion be item 3.
City was called for. But
90 days has already been.
Sorry?
90 days, 16/3/2023, he was arrested. And today, 90 days has been completed.
we will take instruction as a better case filed on it.
Forwarding report has clear, is 15 matter.
Date of forwarding is 21/3.
How do you say 90 days? Not 90 days. Not yet 90 days.
Well, he was arrested on 16/3/2023.
Hmm.
And
So 63 means, when was he forwarded?
21/3 of
90 days.
90 days. You get your instructions at 2 VC, at 2 o'clock? At 2,
March.
Otherwise, also 90 days is not yet to be completed.
you get your instructions. See,
Item 4. So in this case, my city may be called for and there will be taken up along with my DA number 197 already become 23.
hard learned council for the parties,
23.
call for CD along with, call for
197.
CD along with FSL. Fake currency.
Okay, currency, right?
It is submitted, the similar matters are listed on
23, right?
23. Accordingly, let the matter be listed along with BA number
1972 of the 2023.
1972 of 2023. List on 23.
All right.
5.
Yes, we can.
In this case, my district will take up along with item number 19 20. Another case of
You are appearing.
I am referring for item number 5 mega.
Hmm.
And here, similar matter description 19, item number 19 and 20.
Today,
Today.
who is appearing in 1920?
Another comes here.
All right, item 5 along with 1920.
Today.
Item 6. Red Landed Council parties. Call for CD. We call for CD.
Lordship,
What is the,
MRT Lordship, on 30th of June,
yes, it's the last day,
Lordship. Lordship,
26, call for CD along with,
what is going to be case level?
in the case study. List on 26.
Lordship.
7. Councils. Call for CD.
Lordship.
Next on, it is coming from TU.
You will already. On
Nobody
26.
is nearby. 21st,
Lordship.
21st, list on 21st.
Item 8.
Our learned councils. For the parties, call for CD
On 28th of June.
along with the report of the veterinary surgeon, animal husbandry veterinary surgeon.
Lordship.
This is from
It is from
South.
Gachar.
South.
South Salman.
When 27,
28 Lordship.
28.
Lordship.
Supplementary list motion be item 42.
Not legal. This is 439 application of state. Currently, given the states of 50. Petitioner is a 60 years old person and he has been arrested on the state of LBW issue. And not kindly we find the order with the Partly, 35% number 80 lordship. Only one day lordship, and on that very day lordship, the petitioner filed a petition by his English advocate along with the supporting medical paper also lordship. And page number 18. Middle person lordship, middle person. Learned counsel, have you got lordship?
Yes.
And learned middle person. Learned counsel for the petitioner submitted that the accused persons could not appear due to illness. No medical or supporting documents have been submitted by the petitioner. Considering the, so I am of the view that alone further, the accused person would not delay to proceeding further. The accused is proceeding for the offense shown, so the accused persons above named have been shown at shoulder, and the prayer of the petitioner is rejected and declined to the and only one dead lordship, and he is a 63 years old person. So kindly lordship kindly allow him to go on bail and he pays the time lordship and subsequently. And but lordship in this case, these three sons lordship, and they are appearing regularly. But it is very unfortunate, and they are residing in the same campus, same residential campus lordship. But the IO, how can they submit the charge sheet against them from ex-conduct?
Where is the charge sheet?
Page number 8. 11% I had typed. Page number 8.
Page number 8. Yes.
On
Page number 10.
the lordship text of the case.
Yes.
Very good. Para number 7. Source of information, nature of offense and so circumstances connected with it so concise, detailed and under what section of the penal code charge. The brief fact of the case is that as per the FIR lodged by the informant from Mufaddal Farm, son of so and so, residential so and so, district so and so, Assam, a case has been registered and started investigation. During the course of investigation, visited the place of occurrence, interrogated the witnesses, and sufficient evidence have been found against the persons, namely Shahjahan Ali, Jamal Mia, alias Jamal Sheikh, the petitioner lordship, Kansun Nisa, Qasim Ali, and the charge has been established under section 304B, under section 34. The accused person, namely Jamal Mia, alias Jamal Sheikh, Kansun Nisa are absconding and hence claiming before the Solomon court to trial the accused persons and accordingly submitted the success. The witnesses mentioned in column 6 will prove the case. We mentioned that herein that the several attempt has been made to arrest the accused person, namely Jamal Mia, alias Jamal Sheikh, Kansun Nisa, but could not arrest them as they are absconding along with the success. Is correct, so it will not been submitted. So these three sons and all they are residing in the same family and same residential campus. And it will be shown they are the
What is the name of the petitioner?
Jamal Mia is Jamal Sheikh.
Jamal Sheikh absconded.
And
When was it filed? 30/11. No. 24/8. 24/3. 24/3 he was absconding. Then when did he receive the summons?
after receiving the Tamil
When did he receive?
Is number 15.
15.
2023. On that video, also take steps also. Accused Shahjahan Ali, Hasan Ali are present. Accused Qasim Ali, Jamal Sheikh and Kansun Bibi are absent with steps showing the.
So you never appeared. Why have you not appeared? Which steps? You are absent which steps?
Thereafter also he.
You are absent on 3/3/10/3.
Only three days long.
Only 3 days. Why you are shown as an absconder? Then you choose not to appear. Why?
Some problem is there, even bail should be arranged.
Then your counsel appeared on 35. 305. Steps taken. Was any steps taken?
Is the taken, but rejected. Case number 18.
You have refused to appear.
And then lordship subsequently he will appear. Lord.
No, why? Why should we grant you bail now? You refuse to appear, you appear.
Now
You appear, pray for
I am
recalling. Yes, madam.
His lordship, it was earlier fixed on 10/6, lordship, what had happened on that day. So will be again.
When is the next date now? We don't know. You get your instructions next date.
I am repeated, lordship.
When are you going to appear? That is what we want to know. You have not said
At 2 or 12.
that too.
Lordship. Alright.
Item number 43.
44 may be taken up along item number 23. So 22 already called for taking.
Who's appearing in 23? You are appearing.
43, 43, 40,
So let us take up 43,
43 and 44.
44 and
And item number 23.
23. So what is in 44? BA.
42, 44, A.
So we call for CD.
In item number 23, series received.
Arising out of the same.
10,
As one hour previous stated.
10, 10. Not from here.
The 23 is for bail hearing.
Arising out of same case.
If both the cases, my lord, 43 and 44, the
Bail
petition
hearing.
already.
We'll take it up. All right, we'll take it up along with bail hearing. Yes, all right.
Already.
For motion item number 9.
This revision was in fact it is the order of the page number 30 lordship, page 30 lordship. My one, I lordship, the vehicle was referred, the fish was a police study. Also there is not connected in the cancer. Even I was not connected. But that vehicle also even lordship, not for a record, it was for the investigation. But that vehicle lordship was a lordship division. But that's connected to. But only said, but they have the power, they have the power. But I can do it. So, madam, I have given liberty to approach the IO. Again, I went to the IO. I repeatedly requested the IO. When I have written that, the court has equally granted with us, so we also can. That's why the vehicle is getting before the IO. But after the vehicle is after not connected in the sector.
You get a report.
No, sir.
Maybe.
Right, none councils. Issue. Will be issue notice or you get a report.
Lordship, only reports.
Another APP, MS so is permitted to call for a report, police report.
Lordship.
In respect of the Zima of the two-wheeler bearing number AS 14N6925. Which the petitioner claims belongs to him. Based on. When did you get it?
Lordship,
GRP is okay.
can it be on lordship, 27?
27, 23rd,
No, sir.
23rd.
Sorry for mentioning the item number 8, there is a typographical error, instead of 379, it is written as 370, therefore the method is written before the total code. I'm sorry. And the method of, I will be allowed to correct and we will listen to appropriate there.
We have already called for CD.
On 28th.
And code use of the bill payer was there in item code number 3 today also, I was doing that, but item number 5, that is fixed on 21. So can it be on 21?
21.
21.
All right, 21. Item eight, list along with.
Along with 207, PA number 2070-2020.
Yes.
In the respect, I will be allowed to correct in presence of registered.
You correct it on the next day before the court. You correct it. It's only at the time of maybe addressing the matter, you can correct it, but.
Item 10,
First, may kindly take up the matter after some time by senior or making code number.
Time being. 2 o'clock. 2 o'clock.
Okay.
11,
This is the case for quashing of the proceeding, including the charge date matter. As because my lord, the petitioner is only the junior engineer, and he has no role for selection and awarding work to the Indira Awas Yojana. So at this stage, my lord, I'll call, lordship, I'll make prayer, my lord, to issue notice and call for the record along with my lord. The interim prayer will be considered after receiving of the.
Right, councils for the parties. This criminal petition is filed with the petitioner praying for quashing of charge sheet number 09 of 2023, dated 28/02/2023, arising out of Albury PS case number 57 of 2015 under section so and so. And is presently pending before the court of CJN Boxa at Musalpur as PRC number 1316 of 2023. The learned counsel for the petitioner submits that the petitioner is a junior engineer. The petitioner is a junior engineer. Junior engineer, and he is not connected with the offences alleged.
As per guidelines, my lord, my job is very limited.
What is IAY?
Indira Awas Yojana.
And where are you working as a junior engineer?
Now, my lord, I am under suspension.
But where were you working?
I was working there, my lord, now under
No,
suspension.
there means where? Where?
Govardhana Development Law.
He was working as under the Govardhana Development Block. Also, certain allegations were made in respect of allotment to benefits under Indira Awas Yojana houses. Then also learned counsel for the petitioner submits that he, being a junior engineer, he is not required to decide on the list of beneficiaries for allotment of the benefits. Consequently, the allegations made against him are unfounded. Also, the IO or ought not to have filed the charge sheet in the present form, arraying him as an accused. And the learned court of CJN ought not to have taken cognizance of the matter. So the agreed present criminal petition is filed. Let notice be issued, returnable 4 weeks, since MS S.H. Bora appears for the respondent. Will appear for 1 and 2.
Whom my lord, G. Assam.
Appears for respondent 1. And G. Assam, who is there? G. Assam. G. Assam appears for respondent 2. Notices are waived, however, extra copies be furnished within a period of 1 week from today. Let steps by registered post be taken on respondent number 3. Meanwhile, the registry to call for scan copies of LCR connected to PRC number so and so. The interim prayer of the petitioner will be considered upon receipt of the scan copy.
Lordship was fixing any date, ma'am. Any date, ma'am.
List the matter again on 27th of July.
item 12,
Government Council of London.
We have this. Part of the matter for the time. We have been late by senior advocate. Engaged for number 1.
Thirteen. Yes.
This petition was earlier rejected by the body in cancel. This is the supplement second bailiff petition.
Is it required to go before the?
Indian lordship, please may call for the case that is occupied one step will be.
If we can't take up, we can't take up.
Lordship.
If we cannot take up, or if it is to be before an appropriate time, so let it be before the appropriate time. It's submitted by your councils for the parties that. The,
That on page
this is the second bail application
39.
preferred by the petitioner. Also accordingly, let the matter be listed before the appropriate bench. As submitted by. Councils for the parties.
Much already.
40.
Yeah, please, Article 38, verification. Manchester CSK number 193, under section 366. FAR page 8 letter. May I read it?
Yes.
We due respect back to state that last on 25/04/23 at around 12:30 PM night, my 17 years old minor daughter Alamoti Begum has been found missing from the house. Later on, I along with relatives went out in different place and get to know that the recruit person has kidnapped my daughter and kept her in unknown place. It is delayed in lost the affair for being made third that it may be mentioned that the accused person has kidnapped my daughter. So what should kindly see page 12 on home affairs. On today, 27/04/23, Thursday morning at about 10 PM, a meeting was held under the presidency of Rafiqul Islam in the coordinate of Rafiqul Islam, husband of Hamsun Nehar, Mundal Anganwadi worker of 12th number Anganwadi center.
Yes, madam.
Lordship, because as per the FIR, the victim is a minor, right? It's 17 years. So let it be on, it's from one culture, city along with past 64 and medical report. Because
Let it councils. for the-
Lordship, Ekul also minor, Lordship, 19 years. Kindly Lordship, page 12, last paragraph, Lordship.
Minor under for marriage.
No, Lordship, kindly see, Lordship, last paragraph, page 12.
Uh,
Both of them have handed over to their guardian with a condition that after attending majority of boy and girl, their parents will decide with the help of local people, Lordship.
All right, so let us call for the CD.
Lordship,
While current council for the parties, call for CD and with medical and 164.
Lordship, kindly instant protection.
In the meantime, the petitioner is also which will be released on the front and the from of these 30,000. One local security. Subject to the satisfaction of the SC authority. And subject to satisfaction of the following conditions, we will appear before the IU within 7 days from today. We will not enter or temporary evidence, we will not influence or attempt to influence any person to witness, and it shall not move out the jurisdiction of Mankasha PS without put permission to the IU. At least stay in on
17th of August.
17 August.
Obliging, visible of that.
Item number 15.
Next is, number 1 is applicant, number 2 is a married law.
Where is the FIR?
FIR is the case, it is 3540, right?
Yes.
Then, ma'am, with due respect, I beg to honor to inform you that Mr. Franklin Gogoi, with whom I am married for 7 years, has left home on Monday 17 April after an alteration of what among us due to some disputes related to the mismanagement of the property, where me along with the husband reside continuously for last 1 year. Although we did not shifted into the flat as we were unable to get the agreement needed to move into the plan. After providing our all documents to the owner, which is now and shifted to a fact P204 of PR residency from just a few months later, a resident of P202 named Pradaksina Sharma and Nilekhan Guptami type here based from the address surface we should get as a tenant after paying of the monthly amount of 60,500. The woman named Pradaksina Sharma also asked Constantine Gugoi and tenant to legal Assam me last year. Nowadays, they are constantly stalking my case before coming to our home. As Constantine Gugoi is the employee working in a completely different time zone of USA and as a parent of few government exams, we are facing a lot of issues within the society due to the mismanagement. They do not have any notice board where they can provide necessary instruction regarding the rules of the society. The society even does not provide any money received against our contribution towards the purchase of water as decided by them to resolve the issue. The state couple all the time complain against us to our owner presently residing in Kolkata. We as tenant feel so harassed in this due act of nuisance. Due to the negligible attitude of the owner, they nowadays prevented me coming to my door. Today, they needed from me, failing from the test to putting on me that definition of crime. When this due is misusing the power of being owner of the pet. Due to their propaganda, we and the team used to have argument over the activities which are caused as by two in the name of the good governance of the society. As an employee of the private organization USA, he to maintain decency while facing a lot of hardship in performing his job in US time zone. This alteration came so bad that on Monday he left home to perform his duty so that he can help his ongoing private project of the government department. And I had no clue where is he, although he told my mother that he is in some hotel. Hence, I being the first to arrive at home at your station today in search of justice, as his parents do not cooperate, as I was not your selection for marriage. I faced a lot of harassment from my mom-in-law and sister-in-law because they both were only involved in the whole process of my arranged marriage, which Constantine Gugoi termed as love marriage. Although for my marriage of 7 years, I took on blame portrayed by me by my in-law family. I will be grateful to you if you help me to find wherever my husband and protect me, the couple of B202 who are trying to destroy our marriage image in our society. And accordingly, it's later under
Who are the petitioners?
petitioner is the husband.
There are
Petition
three
number
people.
1 is the husband,
Ah,
and 2 is the mother, and 3 is the elder sister of the petition number 1.
yes, madam.
I have not found any torture on the part of the husband among this family. Only there are some fact issues.
Hard knowledge councils and parties. It is registered as what?
498 may not be attractive.
Hard learned councils for the heavy parties. This heavy petition is filed by the petitioner looking for anticipatory bail as they are apprehensive of being arrested in connection with S2PS case number 856 of 2023 and discussion. Also, it is submitted by the learned council for the petitioner that by FIR 2004/2022. The informant largely made several allegations of harassment against the petitioners. And accordingly, he said a fire was registered as the opposite case. Now, as the police has started investigation,
petitioners apprehend that they may be arrested, therefore DAV petition is being filed. Parallel DPP submits that CD along with medical
164 statement.
164. Equal vote. Then I having heard learned counsels for the parties, this court is reviewed that CD along with 164 statement would be necessary to decide this issue. Let CDL 164 state along with 164 and medically available be called for. Meanwhile, if the petitioners are arrested, they shall be released on condition of bail bond of rupees 30,000 with 1 rupee salary of right amount. With satisfaction of the arrestees of the fee and subject to following conditions. Where is petitioner 1?
Can I got it?
In Guwahati?
Yes.
He can leave for US.
Oh,
They will appear before the IO within 7 days from the date. They shall not hamper any evidence or influence any person or shall move out of the jurisdiction of the school police station without written permission of the IO. List on 17th.
right.
Supplementary release for motion item 45.
None appears this next week. None appears for the petition on board. MSSH Bora appears for the respondent. This next week.
Daily list for
Your
admission.
Worship, under occasion in item number 45, Dr. Scan copy of Elser was confirmed. How it was from the motion.
That's where I see. Well, sir. LCA call for has not been received. Registry to issue reminder. What is your name? Right, name of Mr. So-and-so. Interim order passed earlier will continue till the next date, list on 26th June.
Daily list for admission item 16.
No, may I give you the notes?
Yes,
May I give for a minute for return because the petitioner, he is in a very, condition is very bad. And he is also trying to immediately settle with family members. Both the persons are cousin brothers. Which time may kindly be.
land and council for the petitioner submits that there is a process ongoing for settlement of the dispute out of court between the parties. He therefore prays for some time. MSSH Bora does not object to the prayer for me. Accordingly, list after list in July 19th. Entering order passed will continue to the next date fix. On that,
Item 17 and 18.
But in this case, also I will belong from and also to file addition to affidavit. I will let this two matters make after taking last week. And I hold my hand.
at joint request, this,
No, but I am not the case.
you said okay?
But I am giving consent.
No.
Worship, I say worship to file additional affidavit.
Whatever you want to file,
Worship that observation and the other.
right?
Partnership is needed for.
Learned counsel for the petitioner submits that an additional affidavit is required to be filed. Permission. The permission is straight for his granted list.
Last week of July, like. Subject to confidence and.
4th of August,
Worship. It may be third or like.
4th. Right.
Supplementary list bail hearing PA item 46.
Thank you, Your Worship. I am looking at the legal responsibility.
Madam, there are 439 applications, total 7 numbers of which are equally aligned with the United States behind the bar since 30/11/2021. Total 593 days completed. So in this case, madam, I am not arguing about the length of the case, madam. Because I am entitled for bail. Charge sheet already filed, madam. Most of the witness,
How many witnesses? Examine.
and most of witness already said.
Lordship, scan copy of register was called for. And there was a.
Here, I- Received it.
There is office note.
Scan copy available. You guys, as informed by court master. Office note says it was received. Section 11. I will verify it after some time. Second court master of courts are.
Item 47,
Yes. You wait for some time, we'll find out if CD is available. Sorry, scan copy. Yes.
Lordship, 439 days application, Lordship. The petitioner is behind the bars for 55.
Where is your FIR?
Lordship, FIR is in the press where, Lordship, the place, no, Lordship. Vernacular is in 16 and 5 days on 12, May 12.
Yes.
Sir, respectful submission is there about 20 days ago.
You read the vernacular.
Vernacular, yes. Page 16, Lordship. Page 16, Lordship.
Yes.
সন্মানপূৰ্বক বিনীত নিবেদন এই যে আজিৰ পৰা প্ৰায় 20 দিন পূৰ্বে সোণাপুৰ আৰক্ষী থানাৰ অন্তৰ্গত যুক্তল গাঁওস্থিত আমচাং ধাবাত কাম কৰা শ্ৰী নিখিল দে নামৰ পদকীয়াজনে নিশা আনুমানিক 2 বজাত উক্ত ধাবাৰ এটি ৰুমত মাতি নি বলপূৰ্ব মুখ সাৱটি ধৰি বলাৎকাৰ কৰাৰ চেষ্টা কৰে চেষ্টা কৰে যদিও মই কোনোমতে মোৰ প্ৰাণ ৰক্ষা কৰি ৰুমৰ পৰা ওলাই আহোঁ উক্ত পদকীয়াজনে প্ৰায় মোৰ একেলগে কাম কৰা শ্ৰীমতী মুন ৰাহান শ্ৰীমতী অনিকা ৰাহান আৰু শ্ৰীমতী মীনালী গৈমাৰীৰ ওপৰত যৌন নিৰ্যাতন চলাই আহি আছে উক্ত পদকীয়াজনে এই সমগ্ৰ ঘটনাৰ বিষয়ে কাৰো আগত প্ৰকাশ কৰিলে আমাক কানে মাৰি পেলাৰ ভাবুকি প্ৰদান কৰে That is the allegation, Your Honor. It has been filed 20 days after the said incident happened and Lordship, RTI has been given, Lordship. Someone has written the FIR. Lordship, the main reason for filing of this FIR is, Lordship, that this accused petitioner is a part owner of the Amsang Dhaba. He and his father has been maintaining the Dhaba since January. Then in March he left the Dhaba with a condition that his brother-in-law will pay the expenses. Then on 21st, Lordship, before filing of this case, Lordship, on 21st he went to the Dhaba to bring the money. Then they filed a case of murder, Lordship. But after interference of the family, that case was taken away. Then after that, Lordship, on 22nd, this case will file, Lordship.
What basis are you saying?
Lordship, they have been running the Dhaba, Lordship.
No.
I tried to find any
No, you said that
document, Lordship.
there was some fight and somebody filed an FIR.
Lordship.
Earlier, some FIR was filed.
They are the workers of the Dhaba, Lordship.
No, that I understand. You said there was a fight quarrel between the petitioner and his brother-in-law.
Brother-in-law, Lordship.
Pursuant to that, was there any other FIR?
Lordship, they tried to file a complaint, Lordship, but in the interference of the family member, that FIR was taken away, Lordship.
Yes, Mr.
My lord.
I have received the case, then, madam. One statement of the victim, madam. And there are 4 victims, madam. And ultimately, there is only one victim, madam. This is my allegation is clear, madam.
The allegation is not attempt to rape, not it has been. In the forwarding also it has been said that in point number 2 of round of errors noted. During course of investigation, it is learned that the accused person had
What is the name?
tried to commit rape.
What is the name of the see FIR informant is?
Ambika Ram.
How many days now?
Not 55 days.
Then
I have actually considered on the grant of 1800.
Malak here is 164 station minus 3 are Malak Ambika Ram. Yes, the other victims are also supported her madam. They also suffer from the madam that presentation of madam.
My humble prayer is not that grant of 1800 may be seen and not if the allegation is regarding attempt to rape. And already he has been behind the bars for it.
it is not attempt to rape allegation because the statement is actually.
Minor,
omission.
it is
Omission. Yes.
not a criminal.
And submitted on the its of the fire. It is only the date under it. This family is affected.
Under instruction offenses minor
55 days, but it
is 90 days. only.
When was the FIR lodged?
FIR was launched on 22/04/2023.
20?
2/04/2023. And it was sent to judicial custody on 23/04/2023.
Why the medical was done after 4 days?
Minor
1 week, in fact. Why? Why was it done after? What is the reason for the delay? Any reason noted in your case diary?
minor.
If the offense is committed, an offense of this nature. If you send the person for medical examination after 1 week,
Nothing will.
what will it be? Who is the IO? Who was the IO here?
City was come on various occasions.
You get a report from the IO, why the medical was done after 1 week, and in an allegation, in an offense of this nature. You get a report signed by him and presented before the court. Do it by Monday.
Even if they appear.
If he appears, he appears. If he doesn't appear, you get a report why the medical was done after 1 week.
Right.
The medical was done on 34, was signed on 34. When was the FIR lodged?
22/4.
It is shown that it is on 23/4. But the sign of the doctor is on 34.
And there is in the initial page, there is a date of timing and date, time of examination and date of examination. Electronic.
Only the date.
The report may receive after on 13 matter. Is 0 matter.
It was examined on 23rd at 2:30 PM.
Matter. But on report may matter submit on.
So, but examining doctor signs it on 30.
Right.
What is the meaning of that? Who has examined?
Doctor on when it was examined on that death matter. The report may come later on.
This is not the report. This is not the report.
Report comes later. No minor. Thereafter another report is there.
This is an opinion.
Minor opinion.
This is the opinion. So the moment you examine, you get the opinion. Why was it signed after 7 days?
And also in the ION also say that it was collected later on. Report.
No, collection later on is a different issue.
Minor.
But the examination, if the victim was sent on 23rd and examined on at 2:30 PM,
Right.
then the report must be on the same day. Unless there is a reason why the opinion at least. It's not a pathological or a radiological report that you have to wait for 48 hours or 72 hours. This is the opinion. As given by the medical officer upon examining of the victim. Doesn't require one month or 1 week's time.
The last page also medical seen it medical also dated report.
You get a report from the IO.
Right.
Your allegations are very serious.
Right. Not
So this 40 days, 50 days itself will not help. But the medical report is in your favor. Therefore, we want to find out. List on Monday.
Right.
Learned APP will call for a report from the IO as to why the medical examination of the victim, which was shown to be on 23/4/2023, within bracket, the date on filing the FIR, bracket close at 2:30 PM before the GMCH. The opinion of the examining doctor from the Department of Forensic Medicine and Toxicology is shown on 30/04/2023. Please, on Monday.
My copy of the order, my lord.
Copy of the order is marked to the office of the PP. Not yet.
Monday.
I see. Yes, LCR is there in the earlier matter. LCR is available.
Item 46.
You have to go through, okay? You have to go through the Excel.
Note.
My current friend is taking some time to make
Next week,
next week. Today is 7th.
Huh?
Monday, Roshan, Monday.
Monday, all right, Monday. The request, your request is on Monday.
All right, all right.
Item 49.
Yes. Where is the case diary? What is there in the case diary?
Today, 90 days is there, my lord.
51 cases.
91.
You have not filed the charge sheet. Why? Why have you not filed the charge sheet?
Well, now the issue is there, my lord, which statements are not there.
Third level counsels for the parties is the bail petition is filed by the petitioner. So and so. Praying for bail as he was arrested in connection with Katikau PS case number 443 of 2022 under section so and so. Also, it is submitted that the petitioner was arrested on 16/3/2023 in connection with the aforesaid case. Also, this court had called for case diary on 9/6 and 13/6/2023. Today, when the matter is called, the learned APP has produced the case diary. Also, it is seen that the petitioner has completed 90 days, completed the mandatory period prescribed under the statute. Mandatory period of detention, mandatory period in custody as prescribed by the statute. Learned Council, learned APP for the state submits that charge sheet in the matter has not yet been filed and investigations have not been complete. Accordingly, the learned counsel for the petitioner submits to the petitioner to be released on default bail as his rights are accrued under section 167 of CRPC. Having heard learned counsels for the parties, this court is of the view that a mandatory period as prescribed in this statute has been completed and the petitioner is still in custody and charge sheet having not been filed, the petitioner is entitled to be released on default bail. Accordingly, as laid down as the law in respect of rights accrued to detainees who are in custody beyond the mandatory period has been laid down by the apex court. in recent judgments. Therefore, this court is of the view that the petitioner must be released on the full bail. Accordingly, the petitioner is directed to be released on bail, upon furnishing a bail bond of 40,000 with one local security of like amount with the satisfaction of CJM Kamrup Metro. Petitioner will continue to cooperate with the investigation and appear before the IU till completion of the investigation. Petitioner will not move out of the jurisdiction of Atigaon PS without written permission from the court. Bail petition according to disposed.
And accuracy.
Time being item 12.
I'm sorry, my lord, and we don't make that our guess. I mean, relating to petition. What you know, FIR, the considering time my FIR to be
18.
18, page 18, my lord,
Yes,
11, page is my lord, 20. my lord. I've been there.
yes.
Presiding sir, Kotishka Police Station, Guwahati, 29, coming, 18th day of February 2021. Subject, wherefore taking requisite action against the official of the Flipkart and official of the SBI. Bongaigaon branch for hatching a criminal conspiracy against me and misappropriated sum of rupees 38,706. Sir, I would like to bring you notice that the below mentioned fact for your information and necessary action. Sir, I am a customer of SBI, Bongaigaon Bank, having account number 7%. Sir, I have purchased seasonal 4P size food paid from Flipkart in the month of December 2019 with the help of a loan of sum of rupees 36,999. Provided by the SBI Bongaigaon branch. The associate amount was immediately credited to the account of Flipkart and a loan account bearing number was generated against my saving account number and sum of rupees 6,451 only was deducted from my account number starting from the month of February 2020. I would also like to mention that the month of February 2020, I was informed by the concerned official of Flipkart that due to some technical defect, they would not be able to deliver a seasonal food size bed to me, and the same has been cancelled. Sir, the concerned official of Flipkart also informed me that they had refunded the credited sum of rupees 36,999 only to my loan account bearing number so on 7/2/2020 at 2:16 p.m. by the reference number so. Sir, it was also intimate that intimate to me that in case I need any details, I need to contact SBI customer care and need to realize that issue in the bank finance department. So it was also advised me that I should visit the concerned bank and submit the same back from the gate update. Back from the gate update. Sir, accordingly, I talked to the concerned bank official of SBI, Bongaigaon branch, and intimated them about the issue of they told me that Flipkart has not refunded the sum of rupees 36,999 either in my loan account, bearing number or in account number 20. Sir, after the aforementioned information, I again contacted the official of Flipkart and they asked me to meet with my bank statement showing the transaction of from 24 to February 2020. Sir, I accordingly provided the Flipkart and my bank account statement, but they again intimated me that this seller of the process the refund of rupees 36,999 to my SBI debit card on 7/2/2020, and it should have been credited to my account on 17/2/2020 with the bank refund reference number so. Sir, I again contacted the SBI Bongaigaon branch and they intimate to me that Flipkart have not refunded the sum of rupees 36,999 either in my loan account bearing number or in my account number. Sir, in spite of information communication, rupees 6,451 was debited from my account number on 24 1, 2020, 24 to 2020, 24 to 2020, 24, 2020, 24, 5, 2020, 25, 6, 2020, respectively, and total sum of rupees 38,700 was debited from the account of billing number showing to them. Sir, I have again made a communication with the Flipkart and the official of the SBI, Bongaigaon Bank, and this communication is still going on through there. And it is spite of the same, I have not received any sum of rupees 20%. Sir, from the aforesaid circumstance, it can be clearly discerned that the official of Flipkart and official of SBI, Bongaigaon Bank has a criminal conspiracy against me and we should pay the sum of rupees 38,706 from my account number 2200. Sir, I therefore request you to register a case against me, official of Flipkart and SBI, Bongaigaon Bank, to investigate in respect of the same and find out the real culprit involved and we should pay them 20%. Sir, I have included the copies of the bank account statement and my communication with the official of Flipkart and SBI Bongaigaon Banks. Sir, I have also included the certificate as required under section 65 of the Indian Evidence in 1873. The document submitted. I would like to also state that there was a delay in filing FIR and I have been communicated with the official of Flipkart and SBI Bongaigaon Banks for the last 1 year to 2 months for refund of my money, and I was under the impression that I will get my money back in yes. So therefore, the FIR, my lord, I am my lord, officially sorting my lord, Flipkart, my lord. So my lord, I have already refunded the amount to the bank. We have given the reference number. If anything happened, that is my lord in the end of the SBI, my lord. But you also kindly see this FIR, my lord. This FIR, my lord, without making a party to the company, my lord. Only the officials, my lord. So, my lord, I am these 2 persons, my lord. They are official from Guwahati, my lord. So they are joining 2022, my lord. Now, my lord, 41 notices served on them. That's why they are before your lordship, my lord, for your protection.
41, you go and appear.
My lord, if I am arrested, my lord, your lordship kindly see, because there is no case against me, my lord. Because your lordship kindly see the plain reading of the FIR. It is a out and out civilian consumer dispute, my lord.
No, before you were arrested, you will be issued some notice, because under 41,
My lord,
you will appear.
My
Because they have called you
now,
for.
my lord, I am coming to my lord, crossing of this FIR. There is no application against the Flipkart, my lord. My lord, we have given a reference.
Whatever he wanted something, he did not get it. He is unhappy whether the company,
How 420 will come, my lord?
because the money has not been refunded.
I have given a reference to my lord. They should have, my lord, first it is inquiry from the SBI, my lord. And next, your lord, he has been investigated also, my lord. And next, my lord, page 25, my lord. I have given a reference on what time it was refunded to the SBI. That is also I have given, my lord. As they could have, my lord, inquiry about the SBI, my lord. And it is out and my lord, your lordship kindly civil dispute, my lord. There is no conspiracy, my lord. They are 420, my lord.
Where is the question of saying that it is only a civil dispute? He has not received the money. He gave the money,
My lord, he gave the money. They also agreed that I return it back.
but he has not
Maybe
received
because
it.
your lordship kindly so what is happening in this case, my lord?
Hmm.
Probably by this time he got it also, maybe because I don't know, my lord. But since, my lord, it is my case again registered, and my lord, I do not say, my lord, but that actually your lordship kindly see, my lord, who has got this affair, my lord. You cannot use that much. Please be the
Heard when it comes into the petition. This petition is filed by the petitioners. And so. Praying for washing of the FIR. Number 325 of 2021. Dated 19/2021 under section so and so laws by the informant. Who is the aid is responding. Also. It submitted that the petitioners are employees of the company Flipkart, and are presently posted in Guwahati. They're in Guwahati,
My lord,
but the company has also filed it, isn't it?
yes, my lord, petitioner number one.
Petitioner number 1 is the company, 2 and 3 are the employees of the company. Petitioner number 1 posted in Guwahati. Post of learned counsels for the petitioner submits, learned counsel for the petitioner submits that pursuant to an order posted through the company, through the petitioner number 1 company for purchase of a piece of furniture. Certain payments were made by the respondent number 2. These are online payments,
So bank paid to me and I
How-
returned back to bank.
online
Online.
by the customer.
Yeah. Customer request the bank send to us. So again, we send to bank, then bank will send to customer.
Certain amount, namely 36,999 was transacted through the bank of the respondent number 2, which is the SBI Bongaigaon branch.
Yes.
So, however, because of certain reasons, the company, petitioner number 1 company, intimated the respondent number 2 that the product could not be delivered to him, and accordingly, they initiated the refund process of an amount of 36. The entire amount, or you
Yes,
deducted
entire
something, entire amount 36,999. Full stop.
My reference number, my lord, that is mentioned in the
We
FIR.
just submitted that the refund process was initiated, and according to the petitioners, the amount was already refunded to the
On
banker
7/2020.
of the petitioner, namely SBI Bongaigaon branch. Post of Learned Counsel has referred to the ladies to submit. The refund reference number is IN. How many zeros?
5 zeros.
Sure,
Yes,
50172921.
that is 7/2/2020
Dated 7th February
at
2020.
2:16 PM.
2020,
My lord,
2020 at 2:16 PM. Thereafter, certain communications were exchanged between the respondent number 2 and the petitioner number 1 company that the refund process initiated was not received by the bank and consequently by the respondent number 2. Being agreed, the respondent number 2 is the informant, lodged an FIR. Page number,
my lord.
FIR,
20.
It's 20.
FIR dated
18 February.
18 February 2021. And the said FIR was received and registered as Bokisto PS case number 325 of 2021 under section 19 through 2021. Under section 12. Also, when did you receive 41 notice, 41A?
Did I have a next one? 7/6/2020.
7/6/2023.
No, my lord.
It is submitted that as per the information available to the petitioner company, the amount has already been refunded and is available with the bank in which the respondent number 2 has his account and through which the transaction was effected, namely SBI Bongaigaon branch. However, in spite of the refund being initiated, a notice under section 41 capital A CRPC was received by the respondent number,
No, petition number 20.
petitioner number 2 and 3. ID notice dated 7/6/2023. According to the Learned Counsel to the petitioner, once the refund is effective, there is no question of The proceedings being initiated pursuant to the FIR lodged by the respondent number 2. Consequently, present petition is filed, praying for washing of the FIR. So, Leonard, Leonard APP appears for the respondent number 1 and submits that CD called for. CD is required to be called for. Accordingly, let notice be issued, return in 4 weeks. Since the DPP enters appearance on behalf of respondent number 1, no notices of waived, however, extra copies be furnished within a period of 1 week from today. Steps on respondent number 2 by registered post AD. Now it's in the process of investigation.
No court action will be taken.
You file a bail.
No, my lord, that prima facie FIR does not disclose any
This is in the process of investigation.
No, my lord, your lordship kindly see, since it is a prima facie, my lord, there is a material against us, my lord. Then my lord, proceeding is abuse of process, my lord.
The abuse of process.
So I need to
Is-
protect it, my lord. If your lordship kindly see for it, but there's 49,000 rupees, my lord, there, your lordship kindly see award, my lord. From the very beginning, we have, my lord.
There is no bar in filing a bail. You file a bail.
My lord, your lordship kindly is now in this state, I am crossing of this petition because since there is no immediately not.
Washing of the FIR.
FIR, my lord.
Now the FIR is in the process of investigation. Let
Then,
us
but
see.
this, police station and no jurisdiction also, my lord, this is happening in Bongaigaon, my lord. So that's why I'm submitting, we should be, my lord, at least, my lord, that.
You are aware of the law that
My lord, my lord, when there is a prima facie case, my lord, there is a.
prima facie case is okay. There is a
My lord,
prima facie.
on plain reading of the
There
FIR,
is
it does
a-
not disclose, my lord, any.
Let me make this very clear. There is no prima facie case here because you have not produced any documents
My lord, I have
to
to.
suggest that the money has actually been credited to the account.
I have, from our end, my lord, we have done it, my lord.
You've done it, but where are the
But that is
documents?
done by SBI official, my lord.
There
Because
has to
the
be-
money came the gateway, which gateway, I have to send it back, same gateway, my lord.
That's right. So the gateway documents are
My
available.
lord, gateway I have given, my lord.
Where?
That is. Annexa 3, my lord. Annexa 3, my lord.
NHR 3 is your document.
Yes, my lord.
Gateway is different.
Address
Gateway,
to the
gateway is a different identity.
My lord, address, that is my reference, my lord, given to the customer, my lord. The customer, I am sorry, agreed it, my lord. They have received it, my lord.
We are not disputing your submissions. We are saying that this reference number is a reference number for the refund.
My lord,
When it was processed, when it was received, details are not available here. It is said that refund reference number. According to you, this refund has been,
page 28, my lord.
refund has been granted.
Annexa 4, page 28, my lord.
This is an email.
Yes, my lord. Yes. Refund Flipkart reference, my lord, is showing the same my lord number.
What is that page 29? What happened after that?
Yes, page 29, my lord, they are 28, my.
29. Sequel to the email.
Sequence, my lord, probably.
Not 29, there is a trail email to say that you arranged for a certificate from the bank.
My lord. Then, my lord, it is second mail, my lord, it is when accept page 28, my. Downward, my.
Yes.
On June 9, my. 8, sorry. This, your lordship pen is the last part, my lord.
Yes.
This is
Madam.
an SBI debit EMI transaction that is disposed of
You call for the CD. Call for the CD.
My lord,
We'll give you a short date. Returnable after 2 weeks.
my lord. My lord, what I am.
Till the next date fixed. No coercive action against the petitioners.
Fine.
List on. 28.
Lordship.
28.
My
Call for CD.
Lordship.
You have other remedies, why have you not?
my lord. No, they have a remedy, my lord. They can.
You also have remedies, enough remedies. You are not pursuing.
No, that regarding the no, my lord, there is actually there
We
is.
we are nobody to suggest,
My lord,
but just a passing thought.
Bail hearing AB items 1920 along with item number 5.
Item number 5 and 19 and 23. 20, 19, 20 and 5 also. CSS has been submitted.
CS,
Lordship.
who is appearing for 1920?
I am for 5, my lord.
Who is appearing for 1920? S. Nawaz.
Has
can be taken up for the easy of the action.
submitted.
Charge sheet has been submitted, there is nothing to take. Charge sheet submitted. We'll close it, extending the benefit of interim being granted for another 1 week.
Already item number 19, my lord.
Hmm.
The direction will be given to the petitioner, APL 48 and I put below. Nothing to see.
And Lordship, in item number 20,
Hmm.
2 cities were called for Lordship.
What
One
was called for?
2 cities were called for.
Ah.
On Goripur PS case 03 of the.
No, no, you said it is submitted.
Yes, Lordship, but in respect of another PS Lordship, Goripur PS 19.
What is the case number connected to item number 20?
Case number is Lordship,
Goripur
Goripur PS 03. And in this case, Lordship, item number 22 cities were called for.
I'm asking you, what is the connected case here? 03.
03 Lordship,
So what is the status of 03?
that is CS
The end of the matter.
Lordship.
Third, learned counsels for the parties, it is submitted by the learned APP that charge sheet has been submitted in connection with
Goripur PS.
report PS 03 of 2023.
Yeah.
Registered under so and so. Accordingly, if the AV petition is closed, the petitioner, you write 2 separate notices. The petitioner is directed to appear before the competent board before which the charge sheet has been submitted within a period of 1 week. Also, the benefit of interim order dated so and so and so and so stands extended for a further period of 1 week from today. Yes, number 5.
Consider submitted on 22/5/2023. And I have filed this application, my lord, after submission of charge sheet, my lord.
Yes,
And I have also filed an application for bail. I have handed before the court below, my lord, and prepared a bail application, my lord. And that was my rejected.
so let us call for the scan copy that we could have done in the morning. You wanted it.
My lord, in other case, my lord, schedule.
Third, learned counsel for the parties, he submitted the charge sheet in the matter has been filed. Also, the petitioner is arrested on 29/5/2023 in connection with Goripur PS case 03/2023 under section so and so and so. Petitioners. All the petitioners arrested accordingly. No, all the petitioners arrested on 2 different dates. Yes. Petitioner 1 was arrested on 29/5/23 and 2, 3 and 4 were arrested on 30/05/23. Like scan copies of the LCR, including CD, the call for from the court of CJ and Hubli in connection with the PRC
937 of the 20.
937 of the 2023 corresponding to Goripur PSK 03 of 2023. place after 2 weeks.
And it- it's better,
28, 28 June. Or we 26 June. 26.
Item 21.
Yes, Mr. Chaudhary.
Those 326 is there, madam, because from the FIR, madam, it's for a card is going by. And city was called for, today is the court there. City was called, madam. You know what's called the-
Did he receive, not receive?
It's not 51.
Why? Where is the FIR?
Yes, madam, page 9, my lord, start. Total, my lord, 9% name. I am number 1. But your worship can see the allegation, page 10. Only my lord, that is.
Heard Mr. H.R. Chaudhary, Ghana City Council assisted by Mr. Ayu Chaudhary. And MSSH, Bora London APP for the state. This AV petition is filed by the petitioner, so and so. Apprehending arrest in connection with an FIR detail. (18-1) 2023 lost by the informant. Also, it was alleged in the FIR that the accused persons named in the FIR had got into an altercation with the informant and his family members while they had visited a fair at Mandumala on 16/1/2023 at about 7 PM. Also, subsequently, the accused, it is alleged that the accused number 1 attacked the brother of the informant with a sharp weapon with the intention of killing him. However, in the process, the brother of the informant sustained cut injury on his hand. Also, the other accused persons thereafter assaulted his brother by means of lathi and rod, and also damaged the vehicle belonging to the brother bearing number AS 11B 4020. Most of other persons available with the injured were also sustained certain injuries. Other persons who were there with the brother of the informant also sustained injuries. Also, whereas this court by earlier orders had called for the CD along with the interim report. Although several opportunities were granted, the same has not been received by the learned APP till date. Accordingly, at the prayer of the learned APP, the matter stands adjourned. For
He's terrible.
how many days, weeks, months you require?
Only one time we have taken over. And before that, the matter was assured by the petitioner side. What is on 28th?
28th of June. 28th of June.
Not sure.
Till the next returnable date, if the petitioner is arrested in connection with such a case, he shall be released on an interim bail. Upon furnishing a bail bond of ₹30,000 with one local securities, subject to the following condition that he will appear before the IO within 3 days.
Provided we get
You'll get copy
3 days, madam, continue by 4, 5 days.
5 days from today. And he shall not leave the jurisdiction of what police station?
Opportunity.
So, Patagoni, Koyur,
The PA station without written permission of the IO. It's from 28th.
Not sure.
published.
payload alone. That's be given to the
22.
all payloads.
Same prayer lordship. The size of incident, city is not available.
They submitted that the petitioner is on interim bail, however, the HIS 44 has not been received accordingly. Let the matter be listed again on 17th August,
No.
enabling the DPP to call for the case. Interim will be.
I think 23, 43 and 44.
May page or
Yes,
if we take up item number 44.
what is so special about 44?
Silent knowledge was taken from her. The particular page of the FIR is page 18.
Page 18, please read.
Very nice.
Yes,
প্ৰতি মানুহে কাগজ আৰু বিষয় বুজিবলৈ মাকুম কাগজ খানা দিম দিয়া বিষয় এজাহাৰ সন্মান সহকাৰে আপোনাক জনাও যে মোৰ ল'ৰা প্ৰাঞ্জল মৰাণে সঞ্জয় তাঁতীৰ পত্নীৰ পৰা যিটা পিটিছনা পত্নীৰ পৰা 1 লাখ টকা ধাৰলৈ লৈছিল সেই টকা বিশেষ অসুবিধা হোৱাৰ হেতুকে লগে লগে ঘূৰাই দিব নোৱাৰা মই তেওঁলোকৰ কিস্তি হিচাপে 30,000 টকা ঘূৰাই দিলো বাকী 40,000 টকা মই এই মাহত অলপ অসুবিধা হোৱাত লাহেকৈ বুলি কোৱাৰ পিছতো আজি প্ৰাঞ্জল মৰাণে মাকুম কলেজৰ ওচৰত থকা ডাঙৰ বাইক দুনমণিৰ আকাৰ ঘৰলৈ যাওঁতে আগভেটি ধৰি মাকুম হেবেৰা লাইনৰ সঞ্জয় তাঁতী তেওঁৰ ভায়েক ওম তাঁতী পত্নী শ্ৰীমতী নিতা তাঁতী তেওঁৰ পুত্ৰ জিন্তু তাঁতী আৰু জিন্তু তাঁতীৰ লগৰীয়া চৰিত্ৰ আৰু 3জন ল'ৰাই পুৱা 10 মান বজাত মাৰপিট কৰে আৰু গাড়ীৰ ভিতৰত আবদ্ধ কৰি ৰাখি হত্যা কৰে তিনিচুকীয়া চিভিল হস্পিটেললৈ চিকিৎসক প্ৰাঞ্জল মৰাণক মৃত বুলি ঘোষণা কৰে This is the FIR. Actually, admittedly, they admitted in the FIR that they informant son has taken money from the petitioner. Petitioner attended report. So what happened? Actually, 1,20,000 was taken. As he was not returned in time, she lost an FIR with the Makum PS, and on receipt of the FIR, she was Pranjal Moran was called for a police station, and he promised that he will pay. Thereafter, only 25 and 30,000 he paid, and thereafter not paid any money. On that day, the date of occurrence, said Pranjal Moran, along with his sister, came from the room in front of the house of the petitioner. On his begin, the son of the petitioner informed his father that he passes for Ruth. Then father said that follow him. The son of the petitioner followed him, and his car was found in nearby Makum College, and in front of the house of the rented house of the Pranjal Moran's sister. Thereafter, father of the husband of the petitioner informed the police that he is in that area. The police said that when he comes, that time the car was under lock and key. Police said that when he comes, inform the police, then they will go. Thereafter, madam, gathering was gathered numbers of persons, madam. Thereafter, more about 4 hours.
yes, what is there in the city?
My lord, this is also he took money from the wife of, this is my lord from Isha Kanti Lordship, is a petitioner in item number 44. My lord, after 1 lakh rupees Lordship, he returned 60,000 rupees and 40,000 rupees was yet to pay Lordship. Then Lordship, what happened is, son of this petitioner, Isha Kanti, he along with some other person Lordship, they are arrested, and they are my lord petitioner in item number 43 Lordship. They Lordship pushed him inside the car Lordship, locked the car from outside. Then Lordship after support because he died. This is the incident. The postmortem report is also there Lordship, which is suggested that he died of my lord support. This is intentional Lordship. And all the accused persons Lordship, including the item number 23 Lordship. 23 is the Lordship husband of Lordship, the Rita Kanti Lordship, petitioner number 44 Lordship. He along with the Rita Kanti Lordship, they were Lordship detailing the other accused person Lordship. and not allow him to come after the vehicle.
That is one part.
It is 26 years old person. How can he die of viral suffocation?
Not the time is who opened the card. Who opened the card and who and that he was. Who opened the card?
When his conditions were deteriorated, but inside the car was
Sister of the
they
accused.
opened the car was
Sister of the accused.
even when he was taken to hospital, this person was Nita Kanti and Sanjay Kanti they obstructed him not to take him to hospital. They are all materials in the case.
That team is not present there. The Sanjay that is brother is not.
What is the stage of investigation now?
I mean, this is some accused person yet to be arrested.
How many days?
It doesn't mean accused person.
At 44 and 43, my lord.
28 lordship, this is the anticipatory bail lordship, I was from objection lordship. And other two cases lordship, they have only completed 51 days till now lordship.
What is this only?
My lord.
What is this only?
Yes.
What is this only?
44 days lordship, till now, 51 days.
Not even a single day, not even a single day in custody unless you
My
have
lord,
receipts to show.
51 days
What
lordship.
is this only 51 days? Why 51 days? If you have all the materials, you should have filed your charge sheet by now.
My lord, the other accused person are yet to be arrested. lordship.
Then their detention is
The
not
investigation
necessary.
is pending. lordship. If they are, my lord, released on bail lordship, they will, my lord, detain the witnesses.
They will settle.
They will detain the witnesses because they are
You
they are
have their-
neighbors and friends. lordship.
Do you have that apprehension in the city?
Definitely lordship, because the IO has provided the same diary lordship.
You show us those apprehensions by the IO.
My lord, I have also provided one objection lordship.
So what is
Because they have all
that?
conspired lordship to that is why lordship, he was, my lord, who's inside the vehicle lordship, he tried to come out, he was who's inside the vehicle.
What time of the day? What time did he die?
My lord, he died around lordship, as part of the report lordship,
When did the incident occur? What time?
on 26 April 2023 lordship.
What time?
Time is lordship. At about 10 AM.
Then? What car is this?
My car is a Maruti vehicle.
What Maruti vehicle? How many Maruti vehicles are there? What model?
Model is a, my lord, Baleno vehicle. Maruti Baleno.
Baleno vehicle. So you mean to say that he could not roll down the windows?
No, there is a, my lord, when it was locked from outside, lord. In the vehicle, when the ignition switch should be, my lord, off. The vehicle, my lord, they cannot operate.
Locked from
That's why
outside?
he died of suffocation, lord. Otherwise, no injury, lord.
No, so suffocation. Unless you have materials to suggest that he was killed somewhere and put inside the car.
My lord, no, he was not killed and then put inside the car, lord. He was pushed inside the car, and car was locked and he died out of suffocation,
How is that believable?
my lord.
How is that believable?
My lord, this is from the postmortem report, lord.
Postmortem report has said he's died out of suffocation.
Suffocation, that is why, lord, because the witnesses are saying, lord. All the witnesses, they are saying,
Who are they
that
giving?
he was put inside the vehicle because they were eyewitness. lord. They were present at the place of occurrence.
Person to die of suffocation will take some time.
Hello, the key of the car was it was taken by the son of the accused number, the citizen of the, item number 44 lord. He was not given the car, he was not given the key to open the.
Give us the CD, we'll go through.
My lord.
Pass some orders. Yes, we'll pass orders. Give us the CD. You mark whatever is to be marked,
My lord.
and hand over the CD.
Okay.
Item 24,
You're happy to go? Then you assign it to one particular person. Whoever wants to. Yes.
Second investigation, last case there is case there is not received.
CD along with medical report has called for and 164 not received. The matter is referred, enabling the learned APP to call for the CD and case diary and medical report and 164. When can you get it?
যেরকম গোলাঘাট ক্রিয়েট করছে তাহলে পিকটা তখন
23rd, 23rd,
মাইনর ক্রেডিট কার্ড
23rd, 23rd June.
Alright.
25,
Yes, CD,
It should be updated, injury report is not there.
when can you get it?
28
28. 23rd,
million. I will try.
23rd. Let, it is submitted by Leonard APP. Your name, please?
KK Das.
KK Das, who submits that CD, updated CD is required to be called for. Accordingly, is permitted to call for updated CD along with medical report. And 164 statement is available. List on 23rd. Mr. K. Burwa is for the
26,
Yes,
They will contact PD. It is available. It is available.
yes, let us see. What is the allegation? What is the allegation in the FIR?
This girl, okay, when came out from house at night, at 3, and she was reviewed by this petitioner, and everything is a lot from them.
Yes, let us see. What is there in the CD?
In that city, we have also received one birth certificate, according to which the girl is of 16 years around, moreover, medical report is there, which states that no private injury is not there. Otherwise, statement of the 164 statement of the victim is also there, She has stated that this person, accused person, number 1, he used to disturb her and used to propose her, and he also admitted that he took her to his own house, and kidnapped her. However, the statement of though the other persons 2, 3, 4, 5 were only interim, but accused number 2 has not appeared before the IO.
Why?
He's suffering from fever.
No, suffering from fever.
And so he has submitted medical certificate to the police. Accordingly.
He submitted some medical.
It is not stated that minority in the 21 objection is also there. Specifically stated that he has not appeared, he is not cooperating. It is stated there.
It is the father, he is actually, and he is prepared so. Now he.
No, what is the meaning of required so? There is a direction that you have to appear.
Suffering from actually.
He may be suffering from anything, but where are your documents? Have you furnished any documents here?
Oh, yes, we have.
No, before this court,
Before this.
we granted you interim. With certain, Mr. Counsel, we granted you interim with certain conditions. You have deliberately violated these conditions. You have not produced any document to substantiate your submissions that he was not ill. We'll cancel the interim bail.
I just told that he has submitted original certificate to the police, not a single copy he has got.
Then we are cancelling it.
Not the.
We are cancelling this. This kind of submission is not expected from a senior counsel like you.
You also other person who are actually unnecessarily like.
You get the certificate by Monday.
That's it.
Monday, let him produce. You retain the case diary. Uh, At the request of learned counsel, Mr. So-and-so, matter stands deferred to 19th. Enabling him to procure the place before the court. Documents to support his submission, that the petitioner number 1. Petitioner number 2. As to why the petitioner number 2 did not appear before the IO in terms of the order dated so-and-so. 29/5.
That will need to be retained.
CDB retained, list on Monday. Monday,
Monday.
you furnish the documents, you tell us why you did not appear or we cancel it.
Then yesterday, actually, I went to ask him, he said that he actually already certificate and given to police.
You tell him that this privilege of interim bail is not for the asking. You tell him that if he wants to be on bail, he better give reasons to you why he did not appear.
Item 27.
This matter case, there was FIR is at page 9. Petitioner is the wife of case number 9, FIR name case number 9. He was named FIR.
Yes,
There were some worship.
yes, CD,
But is there issue with it?
what is there?
But there are some land issue, boundary dispute between the party notice, prominent active person notice. Then this bedroom notice, he first came to the house of the this informal notice. And he started arguing, after notice, he went back and he was the other active person notice. And the as far as disease notice, this bedroom notice, he killed the disease and the other active person killed him. There are that the victim person also, where interior of the active person also, including this bedroom notice.
Who is before the court?
They,
Beizu.
Bedroom.
he was arrested, Babu Wilson, Babar Ali and Bahar. They were arrested.
They were arrested, but he person pull the personality who later on died also.
Who the person means?
Pull the person, he was waiting from a distance, place, but he was asking the other person not to accept the other person.
He or a she?
She is the lady. Wife of
Lady, she pulled him, wrote it.
She is the wife of
Then
Bahadur Ali.
the other accused person accepted him.
Bahadur is the accused number 9.
And how many of the accused persons are arrested?
Around 5 wrote it.
What day?
One is Babur Ali wrote it. Then Babur Hussain. Then Behaz Bahaz Hussain wrote it. Then Babur Ali. Then Babur Hussain. 5 partners. The still wrote it, you are here to be arrested.
Yes, let us lead us meeting. What's the name of the petition?
Hasina Begum, Allied Bench.
For the parties. This petition is by. The nearest election week. Momondo appeals case number 474, 2022, under sections where it's giving. Under council for the petitioner Sakti Day by FIR dated 4/11/2022, lodged by the informant. It was alleged that the accused person's name in the FIR illegally entered into the house of her maternal uncle and started quarreling over land disputes. Thereafter, they got hold of the younger brother, his maternal uncle. And attacked both the maternal uncle and younger brother, causing previous injuries in the various parts of the body. Also, thereafter, some other persons also attempted to prevent the accused persons from attacking, but they were also attacked in turn. Also, thereafter, the local people came forward and saved all of them and intervened and brought the injured to the Momondo Civil Hospital. The injuries of the maternal uncle and his brother were serious, and they were referred to Guwahati for better treatment. Brother of the maternal uncle of the informant died on the way. And other injured persons are under treatment in the Momondo Civil Hospital. Also, Learned counsel for the petitioner submits that the present petitioner is the wife of the accused person named as serial number 9 in the FIR. It is submitted that there are no allegations against the petitioner. Therefore, however, number 9 is arrested.
Number 9 not yet.
As such, it is submitted that she apprehends arrest as the petitioner and as the police is investigating the matter in connection with the aforesaid case. Also, as such, the present AV petition has been filed. There, Mr. Borwal under ADP submits that the case diary is called for is available. Case diary presented before the court has been carefully built. There are various statements. There are statements of various witnesses recorded. Statements of witnesses reported under section 164 CRPC also part of the case diary. Also, the PM report is also available in the case diary. The result of the case diary reveals that there are references of the petitioner in the statement given by the various witnesses. Also, however, the references do not implicate the petitioner in respect of the act of killing the respondent number, killing the deceased person or injuring the relatives of the informant. Also, upon due perusal of the materials available in the CD is found no incriminating materials are found in the CD to suggest that Randall and speaking of the state will hamper the investigation which is being carried out at this stage. The investigation has progressed considerably fast. The charge sheet will not yet be filed. For such circumstances, this court is in the view where for grant of anticipating bail can be granted. Also, the petitioner is arrested in connection with this case, but shall be released on furnishing a bail bond of 30,000 with one of 17 back home. The satisfaction. CDM.
Investigating of the
I'm sorry, investigating this, arresting the also. The petitioner will abide by the conditions below. They will appear before the IO within 1 week and complete. And petitioner may not hamper or tamper with evidence or influence any person or move out of the jurisdiction of non-doing. Yes. Without written permission of the IO. If the petition stands allowed, disposal of CD written.
Online.
Item 28.
Yes.
Is there in the petitioner is the parent of husband marriage,
Parent,
and is the mother and father.
where is it coming from? Kamru? Get it next week. List on 19. 21st.
21st.
List on 21st. CD submitted, the CD code for has not been received, list on 21st. For CD.
Supplementary list 50.
Yes, Mr. Chaudhary. The other Mr. Chaudhary. Mr. G. Chaudhary. Is this your matter?
I don't know.
50?
Well, today also I actually told my lord that the external affidavit which I had filed, my lord, that is not on record, my lord. The lordship remember, my lord, the day before yesterday, lordship was directed, my lord, the external affidavit to be placed on record.
I think it perhaps was not brought to the notice of the registry.
I don't know, but an order has been passed.
I know what has been passed. As per the last order dated 12/6, it was directed that the additional affidavit stated to have been filed by the petitioner and was not available in the records. Therefore, direction was issued that the additional affidavit be connected to the case records. Full stop. It is submitted that the additional affidavit is still not available in the case records. Accordingly, let the registry trace out the additional affidavits stated to have been filed by the petitioner on
That is filed on my lord. 30th of May 2026.
3005/2023.
Yeah, and over a copy of it.
Not necessary. And the same be traced out and connected to the case record. Also, copy of this order be brought to the notice of the registrar official for doing the needful. Full stop. CD available.
Yes, sir.
Let the case diary be retained. Till the next date fixed. List on Monday. 19. Let it be on 20.
On 20 minutes.
Or 21st. 21st.
20 minutes.
20. List on 20. Losing.
Daily list for orders item 29.
After my lord, I pray for. After time. After time.
No, after some time.
Lordship, here in this matter, Lordship,
Uh.
we directly filed written objection, Lordship, and today we have filed our objection. Let the matter be come on.
It is submitted by learned DPP that objection has been filed in the matter during the course of the day.
Lordship.
Therefore, the matter be taken up on some other date. Accordingly, let the matter be listed again on 22nd.
Okay.
Senate Council, so and so. Like this.
I think, 21. 21.
21.
Item 30,
As per the office note, the informant was not sorry for that.
Your Honor, I'm appearing for respondent number 2. I've only been engaged today morning, Your Honor. Your Honor may allow us time to file our wakalatnama and our reply.
By office note dated 13/6/23. It is as per office note dated so and so. Service on respondent two was not complete, full stop. However, MS
Maitri Das,
M Das, Learned Counsel, has entered appearance on behalf of respondent number 2. She seeks a short date to complete her instructions in the matter. Mr. B.D. Decca, Learned Counsel, appears with the petition. Please, how much time do you require, madam?
Your Honor, 4 weeks.
4 weeks. List after 4 weeks on 19 July.
Can it be after 20?
26 July. Interim order passed on 25/5/23 will continue till the next date fixed.
Your Honor, I've been instructed to apprise the court that we will receive information that the charge sheet has been filed in this case.
Charge sheet has been filed.
Yes.
You are challenging the FIR. So it is up to them. Decide what they want to do.
You are not aware of that position and find out.
Anyone for the state? I think state is appearing here. MSSH Board, charge sheet file.
What should we have to do exactly?
MSSH Board and APP appearing for the respondent number 1. The case for respondent number 1, we'll take instructions whether charge sheet in the matter is right. Let's take what.
Yes, Your Honor.
supplementary list for orders, item 51. May legal officer. Not the friendly David last item.
Yes, Ogamo, Gerukamo.
Yes, got it. In the earlier occasion, there was a little bit confusion regarding the transfer of the case from Kerukamu to Gogamu portion. We have accordingly taken instruction in respect of Kerukamu, case 37 of the 23 portion. This Sarsit is pending,
Charge sheet is
pending. Not yet, but
Gerukamo.
now this is Gogamu. Now it is Gogamu portion. It's transferred from Kerukamu to Gogamu.
In Gogamu PS 37/23, has the charge sheet been filed or not?
That is not filed.
Then who gave you the instructions it was filed?
It was earlier probably mistake on the part of the council.
Huh?
Has been wrongly because it was transferred from Kerukamu project. In the earlier case, the
Somebody has to instruct you that it is filed or not filed.
no,
So the APP who appeared submits that
no,
it was filed.
no.
So the APP, unless you are saying that the APP made a statement without instructions,
No.
normally no such statement is made.
Not sure.
So somebody instructed, who instructed? The IO.
I was not present at that moment.
The order sheets are clear, who was present, you can find out.
No, we take care of it.
Learned Council, MSSH, Bora appearing for the as for the state of Assam as an APP. On what basis are you making this statement now?
As for the instruction from the office,
In what manner?
telephonic
Telephonic?
instruction.
Why don't you rely on written communication for your benefit? Why can the instructing
Lordship,
clients give you that piece of document by way of an
Yes, yes.
email or something?
we'll get it, Lordship, can it be on tomorrow,
Not tomorrow. Get it
Monday, no?
today.
Today itself. It is possible.
No, there's no reason why it is not possible. Somebody has to give you that.
Not,
Your word is good enough for us.
not,
We are not insisting on a document, but these kind of accidents should not happen.
no.
And the request, as submitted by London ABP, that it was wrongly mentioned that charge sheet in the matter has been filed. Charge sheet has been filed in Gogamuk PS case 37/2023, which was earlier registered as Gerukamuk PS case number 10 of 2023. Full stop. This IA has been filed by the petitioner, and it is submitted by Mr. NMB Chaudhary and Council appearing for the petitioner that he is instructed, he has been instructed by his clients that upon due verification at the before the competent court, it was informed that no charge sheet has been filed in respect of Gogamuk PS case number 37 of 2023, which was earlier registered as Gerukamuk PS case number 10 of 2023. Whereas this court, by order dated, where is the order?
In that order, my lord, your lord, can you page my lord 16, 24/5/2023.
Order dated 24/05/2023, passed in AB 664 of 2023.
Directly to put my lord, but certificate.
The AB petition was closed on the ground that the charge sheet has been filed in Gogamuk. The charge sheet has been filed in Gerukamuk PS case number 10 of 2023 under section so and so, corresponding to GR case number 134 of 2023, GRNK. And the anticipatory bail petition was closed, directing the petitioner to appear before the competent court within a period of 15 days from today. Also, in view of the statements, submissions made by the learned APP, that the submission made earlier was on the submission made before this court was not on correct instructions, and it was wrongly submitted that charge sheet was filed by the charge sheet number 16 of 2023 dated 28/02/2023 in connection with Gerukamuk PS case number 10 of 23 under section so and so IPC corresponding to GR case number 134 of 2023.
It's just a simple. That's what it is.
The order dated 24/05/2023 stands recalled by invoking the inherent powers of this court in order to prevent miscarriage of justice. Also, IA accordingly stands closed. Next thing, AB 6644. In view of the order passed in IA 495/2023. Yes, this matter again after. Do you have the case there?
Not yet, actually.
list this matter after 4 weeks, enabling the learned APP to call for the case diary. As it is submitted, the same is not available because court gave. Also, in view of the order, recalling of the order dated so and so, the interim bail granted earlier will stand revoked, will stand revived. List again on July
17. August.
17 August, all right, 17 August. 17 August. 17 August, if convenient,
What is the copy of the order? Maybe-
copy of the order be furnished to the office of the PP for advisory.
Okay.
Daily needs one, hearing item 31.
Yes, anything further to be heard? We have heard. We close it.
We have already pointed out, on the basis of which circular, the petitioner is claiming Malad family pension is not applicable to her. Local collective page 66.
Hmm.
On the basis of the local collective, the government of Assam Finance Department to dated 26 May 1987. Subject, grant of family pension to families of government employees who retired or died before 1164. Before 1164, petitioner's husband died thereafter, 1969. So, our government
After
service
69, what is applicable?
it is not applicable, my lord. Otherwise-
No, after 69, what is applicable?
Yes, after 69, the pension rule is applicable. So the kindly see account pension credit rule. 143 is applicable. Is 143 A. Page 161, what is this book?
What is the circular, what is the notification dated?
Yes, procedure for family pension
No,
in
no,
case
no.
of recipients of government service.
No, the earlier notification that you pointed out,
Yes, yes, on the page 66,
66.
and it's at 29. There are the guidelines. This guideline is applicable when person died before 1164. Apparently, he died, my lord. He disappeared after 1969. And more than 52 years has this supply is not applicable as per my submission, my lord. And his appointment, petitioner's appointment, lordship kindly noted 31/3/1965. Appointment was 31 March 1965, and he was missing 23rd January 1969. That is 31/12/1969, he was found missing. And now, after that, this notification, after that, we can go for the pension rule.
Under pension rule, you need 10 years.
Yes, no, 7 years.
7 years.
I am go on that, I am go, I am 43A. There is a procedure. Pension rule, page 161, rule 43A. Procedure for family pension in case of disappearing of the government servant. So petitioner case is disappearing, missing.
43 or 143? 143A,
A, 143A is applicable.
yes.
Because I am, may I read it, Maratha family pension and death card retirement gratuity to the family to the government family who suddenly disappears, leaving their families and whose disabouts, whereabouts are not known, shall be granted after observing the following formalities are there, Mother. Where an employee disappears, leaving his family, the family may be paid in the first instance the amount of salary due, leave encashment due.
But this has come with effect from 86.
69.
No, look at the note. footnote 143A and B
Yes.
inserted by notification 29 March. This rule will come in effect from 29th of August 86.
Yes, 67, I think.
Yeah? They're not applicable.
Not application.
Then why are you submitting?
No, no, madam, this is for not, this is a procedure, madam.
No, procedure is with effect from 86. Between 69 and 86, what was the procedure? Yes,
That is also, this rule effect from 67, madam. 1167. 1167, 1967. Rule 142.
no, we have heard on the earlier day.
Yes, sir, only rule.
So we'll close the hearing.
Yes, sir.
Learned Council reserve. Reserve.
I want to do one thing, why I said it, 87 rule is applicable. The, Vatican City, take the page 67, clause 5. Then it's clear. The God of Assam has accordingly been pleased to decide that all eligible member family represented 69 all eligible interjected is shall be allowed to depend on it in both the term as well. The areas may be that what you will find will say that is the period lordship will what will happen during this period is applicable and this notification, that's why this.
So this 67 will continue till 87, 86. That is your case.
Yes, and therefore, we are entitled for that. One problem is also why the AG, I am clarifying that part, they have also in affidavit admitted that I am entitled for the pension. That is not part of this government.
Not saying that.
Problem is,
Not saying that.
accountant general says, accountant, yes, I am discharged on so and so day. My submission on that is there is nothing in this service jurisprudence. The word discharge for the regular incubator. The word this discharge is only for the purpose of the temporary workers. Only in the pension rule also Rule 70 also saying about the word discharge. Therefore, this honorable court in a judgment that is clarified that even in discharge, the family pension is entitled. That is, I have already given that judgment to Lordship in Arya Kadam. That is reported in 2001 KGLD 262.
Well, yes, well,
2001 KGLD 262. I am
page number,
262.
name of the parties.
Name everybody, Rajia Khatun. This judgment holds two things. One is that regarding discharge and the entitled for the family pension. Actually, my case is far better than the on that case. And therefore, in this petition, I am also prepared to set aside that DO order, the official order of discharge. This only.
Anything else?
That is, I am entitled for the pension. The proposal has been maybe sent to the accountant general for payment of the pension. That's it. For every concern, there's our letter, page 61. They written, all the communication meeting of so is pressing for payment reexamine. Reexamine the case and keep considerable after briefing of all questions and the meeting communication attention proposal.
Which page are you reading?
61 and except for 24. Is our letter. After briefing all missing communication proposal may kindly be forwarded. This is our letter. And before that, we have,
What is the date of the letter?
date is 2014. Page X 24.
Yes, please read.
Miss from the subject missing communication and so, sir, I have been forwarding there was an application submitted by so and so. Missing communication in favor of part I inform that the missing proposal of so and so was forwarded to the office, so letter and so has been returned with some observations on to your office by letters and so and so. And the communication missing money is pressing hard for the payment of communication is requested to re-examine again. And if considerable, then proposal can be kindly be forwarded to the office.
What observations? What are the observations?
Observation, my lord, it is recorded, my lord, observation. My lord. The 59 page, my lord. $59 page, my lord. One of the DP was drawn against so and so, and the same was disposed of by discharging him from charges, then from the government, some discharge from charges is not entailed to count his past service, and purpose, and his family are not entailed communication. Moreover, the incident is non-proper defensible to rule 143A, count in code, the officer was missing on duty 69. Further, constable was missing from the coding, but in the police station since because the case there was lost on 26/9/5 at Haldipur, UP, after 36 years of missing, which is completely. These are the observed. And my lord, finally, my lord, this was my lord, annexure 20/368. This is the order of the Department of Home, my lord, and where it is reflected, my lord. I am reading, my lord, is peruse the case payment of commitment in respect of wife of who was found missing from Kodingunde police station since 31/12/1969 after entering 4 years, 24 days qualifying service. The proposal was forwarded to the accountant for finalization of the missing family pension case, which was returned with instruction to forward it to the same to the Home Department as the case was very old one. The Department of Home requested the pension pension department offered their views on the matter. The P and PG department opined that the family pension to the wife of missing constable cannot be granted since the case is neither offered with one dated 29% and nor falls the rule of 143 Assam pension law. In view of the above, the matter is closed. The family pension and so not entitled to it. This was the opinion of the pensioners and the department. But this department is not party rationally in this case.
And this order, in fact, this order is still in the DP, sir.
Okay. These are
This order is still in the DP exam record. This we applicable 87. AP has nothing to do on that.
62.
we close the hearing.
Number 32.
Check, return will be possible for a day.
33. Item 33.
The minors was called. Yes, we had appointed an amicus in the matter.
Right.
So let us inform him if he is available, we'll take it up shortly. Maybe perhaps at 2 o'clock. 2 o'clock.
Item 34.
Madam, senior Mr. Ipina is. Now he is not available. And I'm praying for an accommodation for today also because there is a special bench being constituted. Board number 4 lodging on whether it is at 2 p.m. lodging. And he will be appearing for the Guwahati High Court in that. Probably today it won't be possible. He will appear in the.
Is it partner?
Okay, Madam.
So we release it.
If we part of accommodation, they are asking for money only for today.
He is okay. At the request of Mr. M.P. Sharma, appearing on behalf of Mr. Nair, UK Nair, for the respondents, that was then adjourned for the day. Mr. B. Chakraborty, assisted by MS, so appears for the bench. For the day.
Later.
35 and 36.
You for the petitioner or respondent?
I am for the respondent. For in one case, I am for the respondent, and another, my lord,
For the petitioner.
for the petitioner. That is item number 35. Okay. 80%.
Yes.
May I pray, my lord, will kindly take up 36 first. That is against conviction by the trial court, then appellate court uphold it, then the revision.
You are for the respondent.
I am for the complaint in the trial court, appellate court, I was respondent, here I am respondent in one case. This
No, item 36.
respondent.
Respondent. You are for the.
I am going to petition.
Okay.
I know this matter was heard by court number 14. That's why it has been released.
It was released.
It has come in the last occasion. It has come as spoken to the and then it's for hearing. And again, it's started today.
So,
The senior has almost finished the matter. The last.
so I am not competent to remand it back to court number 14. So we are ready to hear the matter if you want to argue.
Yes.
You want to begin the hearing today?
Yes,
You want to begin the hearing today?
yes, madam, but I'm not fully prepared for it.
That is what I am asking you. Are you ready to proceed with the hearing today?
Yes, yes.
Then
But fully not prepared for it.
what is the meaning of that? Yes or no?
Approximately, I give a short time, madam.
What is the issue here?
Issue is very simple, my lord.
Oh, NI.
And
NI case.
Then
Facts has been proved in the trial court, my lord. Appellate court reappreciate the evidence on record, my lord. And this is revision application where it is very limited with regard to what is the perversity he has to prove from the record. There are two concurrent findings.
yes.
here in this matter, let's see. I had borrowed, let's say, amount 5 lakhs more than let's see.
No. Let us understand. Are you proceeding with the hearing or
I need some time. madam.
then say that clearly?
Yes,
Because don't expect the court to keep it part heard again. No part heard. If we take up, we'll finish the matter.
need some time, madam. It's hearing my.
But it's a 17 matter, so we'll only accommodate you for the day. The request from Mr. D. Bora, matter stands passed over only for the day as it is submitted that he is led by Mr. Swenzu as the arguing counsel in the matter. He is not available in court. Mr. D.K. Mia appears to the respondent. Both matters be passed over to the day. Both the matters.
What date is it?
All right.
Any date been fixed?
It will come on its own. So hearing matters.
Okay. Okay.
Item 37,
Maybe next week.
Next week.
Yes, Mr. Manna.
This matter is basically, your lordship, it's the second conviction of the same, basically. Okay, what has happened? What do you kindly take up my criminal petition? The petitioner has been convicted under the NI Act. In the judgment is starts from page
So why is it fixed for today for hearing?
hearing. But only one point. I'll just come to that very fast. I will take 10
No,
minutes.
no, no. The reason why I'm asking you because there is a hearing list. There is a hearing list. There is a hearing list where matters from 16, 14, 16 are pending. So are we, does it require a priority hearing?
It was only point your lordship will have to decide. I'll leave it to your lordship. Only point that
What is
is
the
to be
point?
decided whether
Hmm.
after the completion of the default period of your lordship punishment, whether again the whole issue was raised. This is basically the.
Something to do with the fine or
Yes,
something like.
fine was imposed and in default, I have to go undergo a sentence.
Hmm.
I have undergone a sentence. Now on the application under 421, they have again issued notice, again warrant, I was again arrested, but before that I was granted bail, I came before this court to stay. Now that is the issue as of the moment.
Where is that order rejecting your application?
Now, first your lordship will kindly take up page, one more, just page 18 for one.
18,
This is the first judgment. I'll just refer to that.
yes.
I'll just go very fast, just 5-10 minutes. Page 80, paragraph 10.
Yes,
Hence, the convict is sentenced to undergo simple imprisonment for 3 months and pay an amount of rupees 6 lakhs as compensation which shall be paid to the complainant and shall be recoverable as fine in default, simple imprisonment for another 2 months. So next step we have, an appeal was filed, appeal was rejected. Now your lordship will kindly go to page 21. I'm not reading the.
so you were sentenced to undergo 3 months, simple, and pay 6 lakhs.
Pay 6 lakhs
In
as
case-
compensation,
In case you don't.
Yes.
Then.
another 2 months.
Another 2 months, simple.
So just showing that. Then you know, page 21. The judgment of the appellate court is not annexed, so I am just referring to the order. Because it has been upheld. Page 21. By judgment and order dated 6/6/2016, the convict was sentenced to undergo simple imprisonment for 3 months and to pay an amount of 6 lakhs as compensation. This shall be recoverable as fine to simple imprisonment for another 2 months. The complainant filed a criminal revision before the additional session judge and by order dated 30/11/17, the convict was directed to surrender before the trial court within 30 days from the date of the order. The impugned judgment of the trial court of conviction and sentence was upheld and the convict was directed to surrender before the trial court within 30 days. From the date of the order, but the convict has not surrendered. Accordingly, NBW has been issued against the convict, remand the convict to JC to serve out the sentence. The superintendent of jail Kamrup is directed to ensure that the accused person receive proper book loading. This date is important because this is on 30/6/2018, the accused was remanded to custody. Now your lordship will go to the next page.
page 23. 28/12/2018. So this is about 6 months from the date of the order, earlier order. Today is the date fixed for necessary order on the petition number 12 on behalf of the complainant praying for recovery of compensation under section 421 of CRPC. Peruse the case record. It appears that by judgment and order dated 12, the convict was sentenced to undergo simple imprisonment for 3 months and to pay an amount of ₹6 lakhs as compensation, which shall be recoverable as fine in default to simple imprisonment for another 2 months. Now, important part. It appears that the convict was remanded to judicial custody to serve out the sentence by order dated 30/6/2018. And since then, she was in jail custody. As the convict was sentenced to undergo simple imprisonment for 3 months and in default for another 2 months, she has already completed her term. So she is beyond one month beyond the time. The complaint petition so prays for recovery of compensation amount from the accused, issue notice to the convict to pay the
You
compensation.
did not pay the amount.
No, I didn't pay.
You did not pay the
I
amount.
did not pay the amount. I have gone through the default period
3
of
plus 2, 5 months.
5 months. I was in jail for 6 months now. Then what happened, your lordship? Then what happened next week? On the basis of the notice of compensation and warrant was issued at page 24. Accused is produced on the strength of a warrant of arrest issued against her. On being asked, the accused was submitted that she is medically fit and she will be engaged to counsel. Superintendent Central Jail is direct to ensure that the accused person receives proper. Now, what has happened? After the default, after 1 month beyond the default, I am again arrested and put in. Now that has been somehow to an extent it has been resolved. That is at page 25. Order dated 4/11/2019. So again, I am in jail with that period. See petition number so and so on behalf of convict so and so, praying to allow her to go on bail. It is submitted on behalf of the convicted by judgment and order dated so and so. The accused was convicted for imprisonment of 3 months and also compensation of an amount of so and so. In default, another imprisonment for 2 months. It is submitted on behalf of the accused that she was arrested on 3/6/2018 for serving out the sentence, and she was released from jail after completing the term of sentence. It is submitted on behalf of the convict that since she has already completed the terms of sentence, and she may be allowed to go on bail. Where is the order dated 28/12/2018? And it appears that the convict has already completed the term, hence, considering the submission where is allowed, the accused so and so is allowed to go on a peer bond of 20,000 with a direction to appear the next day and to pay a fine and compensation amount so and so. Then again, what has happened, dear lords? Next page 26, last order, after that we have come before this one. See the petition number so and so on behalf of the convict. It is submitted on behalf of the convict that on the last occasion the accused was direct to pay the compensation amount, but the convict has already served the sentence for default to pay the compensation amount. Hence, the convict is not in a position to pay the compensation amount to the convict. Therefore, prays to adjourn the matter for today as she will prefer a reveal. Also, seen petition number on behalf of the complainant. It is submitted on behalf of the complainant that on
Your conviction
Yes.
was for 3 months
Three.
and to pay compensation. If you fail to pay compensation, you will be sent for imprisonment for another 2 months. Does it mean that you are not required to pay the compensation?
If I fail to,
So if you
if I
fail to
don't pay,
no, if you fail to pay,
yes,
does it mean that you are not required to pay if you undergo?
I undergo. If I don't pay, I undergo. If I pay, I do not. They can give. Now, 421. Section 421. That says that if there is an order for payment of compensation.
We'll come back at 2. At 2. Subject to your convenience. What is this?
This is a judgment, same, exactly the same issue, but that is not NIA, it is NDPS side. 421 has been discussed, there are judgments of various high court. And then finally it is held that once you have completed your default period, you are no longer here entitled to be put into custody. But one thing I would like to point out, the same issue, can I be, for example, I don't pay. For example, I don't pay the compensation. I completed my default period of 2 months. Now,
Anyway, what happened after that? What
there's
is-
a stay order now for it, printing as of.
Petition is pending there, but regarding the 421 petition is pending, so without that petition being disposed of, they have directly come with it. This petition itself is not maintained on that, because that petition has to be disposed of under section 421, my lord.
No, I am
That has to
coming
be
on the
disposed of.
applicant.
So that part, that petition has to be disposed of, man. Regarding the compensation amount, we have filed, the complainant has filed on petition there. So that, so without this, that petition being disposed of.
And one thing I would like to point out, now, for example, I don't pay, even after this notice of 421, again I will be put on jail for the same offense. That is what I would like to point out. Can a person be punished twice for the same offense? 300, article 300 will be affected there. That is why it is said, you default, you don't need to pay, but there is a rider. There under section 421, there is a rider. That rider has to be there, it is not there.
This point I would be also clear in the apex code circle. I have my lord. Para 28 mechanic.
The 421 section itself is clear. 421 proviso itself is clear.
Oh, what it is said? Why do it say
No,
that
it's clear.
you are not entitled to pay if you go for a default?
That is not the law, man.
Then,
The 421 proviso is clear.
Tomorrow you will take money from me after you should take and then.
You
I
read
will support you just
421.
by going for
you
2 months of shame.
Why don't you read 421 proviso?
Warrant of payment.
Proviso.
provided,
Provided.
this is what I am trying to say. How can I be punished, for example, twice for the
This is
same?
a question of punishment, recovery of from the
Recovery,
compensation.
they can go for a civil court, that is always there.
But
Normally it is done.
that is the government says otherwise, that he cannot be absorbed of the amount which is imposed upon him. Para 28 man.
You give him the judgment, let him go through. Both of you share your judgments. Very copy it out, really. Let's see.
Let it be then after the vacation, we might, no, since your lordship will take up only old matter. Let him-
No, I'm not on that. When the matters are listed for hearing chronologically, we have to give preference to the old matters,
That is
especially appeals
This,
pending.
I thought it was a small matter on the basis of the proviso, it can be disposed of. My learned friend is now taking out some other thing.
No, it may not be a small matter. That is why I asked you that question in the first place, that whether you are absolved,
No, whether I can be punished for the same offense, but
punished or not is a different issue, but whether you are absolved,
yes,
there is a direction to pay a fine. In default, undergo.
yes.
Can
So
you
I
interpret,
underwent,
would you interpret it by saying that once I undergo, no fine?
yes.
Or is it to be interpreted that you defaulted in paying the fine, therefore you undergo the extra, but the fine will remain, you
Fine
pay
remains,
the
now
fine.
how the fine will be? I
Yeah.
don't pay the,
No, there are procedures to
yes, I
recover.
don't pay the fine, again I will go to jail.
350, no,
That is the issue here.
357,
There is a procedure for, I think there is a procedure for
357,
attachment. There's a procedure for attachment, but that will have to be under 354,
357, I think.
357, sorry. So that has to be incorporated in the judgment in order to affect 350. That is what I am trying.
Item 3,
Item 3, madam.
today's list,
Yes, today.
bail application 2019.
Madam. Yes.
It is submitted by the learned counsel for the petitioner that he has instructions not to press the bail petition any further. Accordingly, bail petition stands dismissed as no press.
Madam.
Mr. D. Sharma appears for the
Must.
respondent.
Madam.
Item 37,
Yes,
I have seen the judgment, when I'm kind of right. That doesn't fit the law. It is just quoted that particular provision, saying that it has to be there in section.
this matter is not as
As,
small as we thought.
yes,
It will require some hearing.
but you have it after the reading. Because I also have a mathematics statement in another.
Very well, at the request of parties for the councils for the parties, the matter be deferred till after vacations. Summer vacations. We come on some date, why fix a date? We come on some date, unless you want to
They
pursue the matter because they are willing to spend more time in prison.
Enjoying the stay.
They will spend more time in prison, but not give you the.
Ultimately, they have to pay minus.
He should have approached the civil.
Like a.
That day, when we-
Matter be listed again on 18th July. Interim order period. Provided Mr. Mannan is back in the country.
No, I am get that. It may put it on some other 20th. Because
20th July,
immediately there are 3 cases fixed.
20th July.
Much.
Take that to item 33.
Yes, Mr. Yes, item 33, yes, Mr. Kamar.
Well, I'm sorry, I was not to sign my.
Not, your name is not reflected.
But I was aware, I take it matter and I come to test today also. Because okay, once I should have this, I'm in a position to accept.
Yes, we can, because it is on a question of whether they can withdraw the appeal.
Absolutely.
Very unfortunate that,
Yeah, definitely.
during the pendency, so much time elapsed.
Because I have got nothing to do with the merit. Now, whether what is the legal issue, whether I like to address of that matter. So for that, we have to first go to the appeal provision 386, power of the appellate court.
Yes. Yes.
My latest chapter 29, madam.
386.
Yes, madam. It starts from 372, madam.
Yes.
The relevant provision, madam, I made a chart, madam, which will be relevant. The chapter starts from 372, madam. And the relevant is 374 for to deal with our case.
Yes.
Appeal from conviction, under this provision of law, this present appeal has been filed, madam, which has been numbered as criminal appeal number 159. madam.
Yes.
So there is a provision for summary dismissal also, madam, 384, madam.
Yes.
Upon examining the petition of the applicant, copy of the judgment received under 382 or 383, the appellate could consider that there is no sufficient ground for interfering. It may dismiss the appeal summarily, provided that no appeal prescribed under section 382 shall be dismissed unless the appellant or his pleader has a reasonable opportunity of being heard in support of the same. No appeal prescribed under 383, that is from jail appeal, madam, shall be dismissed except after giving the appellant a reasonable opportunity of being heard
in support of the state unless the appellate court considers that the appeal is frivolous and that the production of the accused in custody before the court is involved such inconvenience as would be disproportionate to the circumstances of the case. No appeal presented under section 383 shall be dismissed summarily until the period allowed for preparing such an appeal has expired. Before dismissing the appeal under this section, the court may call for the record of the case. Where the appellant the court dismisses an appeal under this section is a court of session or the CGM, it shall record his reason for doing so. When an appeal under section 383 has been dismissed summarily under this section, the appellate court finds that another petition of appeal dismissed presented under 382 on behalf of the same appellant has not been considered by it, that court may not be extending anything contained in 393. It is satisfied that it is necessary for the interest of justice to do so here and dispose of such appeal in accordance with law. So the mandate is after comma here and dispose of such appeal in accordance with.
No, come, please. Again,
Yes,
let us go back.
Then there is a white power conferred under section 386, madam. Powers of the appellate court. After perusing such record and hearing
What-
the
what-
appellate on this plea.
What can be disposed of summarily?
My lord, those cases, my lord, when it is first listed, my lord, that it is found frivolous or not in accordance with law, my lord, then those cases can be summoned.
This is an appeal which was admitted. This is an appeal which was admitted.
Yeah,
Yes.
because while dismissing summarily, my lord, it does not to be disposed of on merit.
Hmm.
Only on certain points, my lord, it can be disposed of summarily. So now, my lord, we are on the power of the appellate court, my lord.
Hmm.
Power of the appellate court after perusing such record and hearing the appellant or his pleader if he
You're reading from section
section 386.
86, yes.
Your lordship, while taking up a criminal matter, minor under 374 or whatsoever section. So this is the power conferred upon your lordship to deal with the criminal appeals matter. Powers of the appellate court. After perusing such record and hearing the appellant or his pleader, if he appears and the public prosecutor if he appears, and in case of an appeal under section 377 or section 378, the accused if he appears, the appellate court may, if it considers that there is no sufficient ground for interfering, dismiss the appeal, or may, in an appeal from an order of acquittal, reverse such order and direct the further inquiry to be made, or that the accused be retried or committed for trial as the case may be, or find guilty and pass sentence on him according to the law. In an appeal for conviction, so this is an appeal for conviction, madam. Reverse the finding and sentence and acquit or discharge the accused or order him to be retried by a court of competent jurisdiction subordinate to such appellate court or committed for trial. Or alter the finding, maintaining the sentence, or with or without altering the finding, alter the nature or the extent of the nature and the extent of the sentence, but not so as to enhance the same. So there must be an enhancement petition, then only your lordship can enhance the sentence.
Yes.
In an appeal for enhancement of sentence, reverse the finding and sentence and acquit or discharge the accused or order him to be retried by a court of competent to try the offence, or alter the finding, maintaining the sentence, or with or without altering the finding, alter the nature of the action, or to that action of the sentence so as to enhance or reduce the same. In an appeal from any order, alter or reverse such order, make any amendment or consequential or incidental order that may be just or proper, provided that the sentence shall not be enhanced unless the accused has an opportunity of showing cause against such enhancement. Provided further that the appellate court shall not inflict greater punishment for the offence which in its opinion the accused has committed then might have been inflicted for that offence by the court passing the order or sentence under appeal. And lastly, the most important matter which I would like to refer is section 394 matter. Abatement of appeal. When the appeal without hearing comes to a matter.
Every appeal under section 377 or section 378 shall finally abate on the date of the appeal. On the date of the appeal. Provided that where the appeal is against a conviction and sentence of death or imprisonment and the appellant dies during the pendency of the appeal and or his near relative may within 30 days of the date of the appellant apply to the appellate court or for leave to continue the appeal, and if leave is granted, the appeal shall not abate it. So the definition of relative is also given. So these are the parameters by which your lordship will now will have to take up the matter.
Now, why the provisions of 384 not to be applicable?
Not applicable. 394.
No, 384.
384, sorry.
So in a sense, you are saying that there is no scope to withdraw.
Good job.
The matter will have to be heard.
Now I have got two judicial pronouncement and I have given one very old case to your lordship which has written it matter. Withdrawal of appeal.
Lahore.
Yes, my lord. Emperor was a Jilla Mohammed, year 1942, Lahore. I just read for your lordship and I come to Supreme Court judgment, but if such type of situation arises, probably we can make some derivation from there on. So this is directly on the point, but it is an old case, my lord. In some old cases, it has been held that the appellant has a right to withdraw his appeal. In we do not trust 5 Calcutta, LR 372. To the contrary, it has been held that neither the accused nor the state can withdraw appeal. When an appeal has been filed and it has been summarily dismissed, all the formalities mentioned in section 385 and 386 have to be complied with. The notice has been given to the parties. The court has to read the record. Parties are to be heard and the judgment to be delivered. So this is what is disturbing me. So now,
Yes.
my legal pronouncement I have brought, not directly in the issue is not there, my lord, I could not find it. But a case going from Guwahati High Court to the Honorable Supreme Court, my lord, one Sukur Ali's case, my lord. In that case, my lord, a dismissal for default was made, my lord. Then the Honorable Supreme Court said.
Of the appeal.
Yes, my lord.
Dismissed for default of the appeal.
My lord.
Dismissed for default of the appeal.
Appeal.
Then it cannot be dismissed for default and it has to be heard.
Absolutely. By engaging an amicus curiae.
If required, yes.
Then, my lord, subsequently, that part of that also overruled to an extent. In 2013, 3 SCC 721, that is KS Panduram versus State of Karnataka. Para 15 to 28, it is elaborately dealt with, my lord.
2013.
I have given the citation, my lord. Second one, 2013, 3 SCC 721.
Okay, where it has been overruled.
Yes, my lord. Overruled not the wholly, my lord. On that certain point, my lord, that has been dealt with at para 32, my lord.
Yes.
So,
What does it say?
yes, my lord. Before that, my lord, we can take a glimpse in this 2011, my lord. Sorry, I could not procure the paper. I was hopefully busy today. Hearing matter, my lord. Mohammed Sukur Ali versus State of Assam, my lord. The Honorable Supreme Court was of the view that criminal case, whether trial, appeal or revision, should not be decided against the accused in absence of his counsel. Liberty of a person is a most important feature of our Constitution. Article 21 guarantees protection of life and personal liberty. Is the most important fundamental right and the fundamental guaranteed under the Constitution by Article 21, said to be the heart and soul of the fundamental right. It is only a lawyer who is conversant with law who can properly defend an accused in a criminal case. Hence, if a criminal case, whether a trial or appeal or revision, is decided and accused in the absence of the counsel, there will be violation of Article 21 of the Constitution. As such, even if the counsel for the accused does not appear because of his negligence or deliberately, even in the court should not decide a criminal case against the accused in absence of his counsel, since an accused in a criminal case should not be suffer
for the default of this council, and in such a situation, the court should appoint another amicus curiae to defend the accused. So that was the theory proposed by Division Bench. But in 2015, my lord, a larger bench, my lord, of three, two judges again, my lord, three judges. 7-1. 2-5. K.S. Panduranga, my lord. Similarly, two bench, my lord, as para 15 is dealt with it. But the relevant provision is dealt with, my lord, in para 33, my lord. Shall I read, my lord? Para
Yes.
52.
Yes.
In view of the appropriate enaction of law, it can simply be concluded that the dictum in Mohammed Sukur Ali to the effect that the court cannot decide a criminal appeal in absence of the counsel for the accused, and that too if the counsel does not appear deliberately or shows negligence in appearing before, contrary to the ratio laid down by the larger bench in Bani Singh, is far inferior. We have hastened to clarify that bearing the seat aspect, we do not intend to say anything on the seat judgment. So for engagement of amicus curiae or the decision rendered regard being laid to obtaining factual metrics therein or the rule bar action of the lawyer. Thus the contention of the learned counsel for the appellant that the High Court should not have decided the appeal on merit without the presence of the counsel does not deserve acceptance. That effort it is noticeable that after the judgment was dictated in open court, the counsel appeared and he was allowed to put forth his submission and the same has been dealt with. So there was a judgment Bani Singh relying my lord.
So essentially, it was partly overruled. With
Yes,
regard to
partly overruled.
disposal
Yes.
in the absence of counsel,
Absolutely.
not necessarily mandatory
No,
required to appoint an amicus.
Subsequently, but same bench strike, my lord, to just. So the Bani Singh, my lord, deals with certain principles, my lord, which have been incorporated as para 19, my lord. Para 19, I read, my lord, from the decision in Bani Singh, the principle that will be called out are first, that the High Court cannot dismiss an appeal for non-prosecution simply settled without examining the merits. The court is not bound to adjourn the matter if both the appellant or his counsel lawyers are absent. That the court may, as a matter of prudence or indulgence, adjourn the matter, but it is not bound to do so. That in case that it can dispose of the appeal after perusing the record and judgment of the trial court. That if the accused in jail and cannot on his own come to the court, it will be advisable to adjourn the case and take another day to facilitate the appearance of the appellant accused if his lawyer is not present, and if the lawyer is absent and the court deems it appropriate to appoint a lawyer at the state expense to assist him, nothing in law should preclude the court from doing so. And that if the case is decided on merit in absence of the appellant, the higher court can remedy the situation. So these are the propositions that has been enacted by the Honorable Supreme Court in the larger bench manner. So taking all this into consideration manner, I think an appeal has to be brought to a logical conclusion manner, irrespective of the fact, whether it is possible.
So will you address us on the
Now, from here, as we can find out, my lord, the appeal ultimately has to be disposed of on
merits? So there's no question of withdrawal.
withdrawal. That is my respectful condition, because I am not taking side of any party, but I'm just
Naturally,
saying
naturally.
what I have understood the law.
One would be,
Hmm.
I have not been able to contact the context. And it's one thing, if I withdraw without their consent.
No, that your consent or no consent in the face of the law laid down by the apex court is irrelevant. So now you have to, if you want, you argue or we follow the later judgment and close the appeal.
It's not, like, this is an appeal, understand, against the judgment. In a special case, number 4, 2011. Of Doha, under section 21C of the NDPS. But in this case, there are two appellants there, madam. Originally, there were three accused in the case. One is Dilip Chakraborty, another is Shyam
Shamal Das.
Samandar, and the third one is Anwar Begum, madam. Madam, they all these three persons were convicted and sentenced to 10 years of imprisonment and also to fine of rupees 1 lakh each, madam. Yeah, Dilip Chakraborty, because number one has not filed any appeal. The other two have filed this appeal through jail, madam. They wrote to the legal secretary and legal secretary part changes one Rita Boru Bora madam. And after she left it, it takes us into the what is the regular council. But I have got only the judgment, no other paper is being. But by the judgment is the detailed one. From the judgment, I have collected all the details, on the basis of.
Records are available here if you want. Records are available. Records are available, like LCR is available here. You want to go through the LCR? Do you want to go to the lower court records?
I have the copy of the.
It is available here. Do you want to see it?
Yes, sir.
Okay.
And no paper was prepared here.
Paper book may not be record necessary here. LCR is here. You go through it, we will take it up again. 18 July. 18, Mr. Kamal, available. We'll request you to address us on merits also.
Sure, madam.
If you can.
If the lordship asks me, I will speak.
Or 20. Eighteen.
18 times. 18 July. 18 July.
After hearing the learned counsel for the petitioner as well as the amicus, Mr. Zio Kamal, senior counsel. It appears that the copies of the LCR and of any paper book has not been prepared or furnished to the learned counsels. Considering the time that has elapsed since the period the appeal has been filed, this court considers it, does not consider it appropriate to direct the office to prepare any paper book. However, liberty is granted to the learned counsel for the appellant as well as the learned amicus to go through the LCR, which is available in the court records.
Sure.
Accordingly, the matter will be fixed immediately after hearing, after reopening, list on 18 July.
Right.
For further hearing. You can have a look.
We'll take it.
The postmaster is permitted to. Copies. You may present, you may peruse the reports here.
I do.
Yes, yes.
But he is insisting that
If the copies, photocopy, the deposition.
only deposit.
You go through it. The Courtmaster will give you the copies. Courtmaster will give you the copies.
Much of it.
Time being item 1 and 2.
Yes. Earlier rejected by this court.
Yes.
Yes.
The earlier before completion of 1 month was rejected. Now it's 48 days.
No, you know the law, that number of days is not a new, we must give a new ground.
New ground is that if item number 2. He is the only son. He has to look after his mother. Ferrari was expired, my lord. In an accident, which expired, that aspect was not, my lord, either detailed not considered. This is one of the new ground, another ground, my lord, that four accused are released. By the, another court of this, court, my lord. On credit also, my lord, they are paying this.
Yes, Mr. Sarma.
My lord, I have received the case here, my lord. Here, 164 statement is available, my lord.
It is, I think, on the basis of 164 we reject.
My lord, please, please.
The allegation is of, do with it of 376 money. 376 was not committed. She voluntarily accompanied the accused persons to the view function. And on the way, there was some dispute. And on the dispute, she without this affair. So, no 376 was committed. That case, it can be a case of before.
Co-accused was granted because there was no reference to him.
My lord, there is
164.
not there. No, I think 164, my lord, there. It was in,
That is the ground we rejected it.
my lord.
You think of a new ground if you have it.
But considering the length of detention,
The length of detention is not sufficient.
because
If you want, we can furnish you with elements to say that is not a ground. That is not a new ground.
the additional ground that is the medical ground. Mother still next man. He has to look after his mother. Otherwise, it's not there. He's the only son. I don't know if there is a-
See, we have passed orders, so we can't make an exception for you unless you give a new ground. We have rejected second bail also. If there are no new grounds, and we don't find any new grounds.
The state was not considered the mother's illness. No other allegations are same. Allegations that will not be changed. The city will be safe. Those things will be always safe. But
You show us on some authority that period of detention is a good ground for release in respect of second bail applications preferred.
look, as per our statement itself, my lord, 376 is not committed.
Is?
376
Hmm.
is not committed. And she voluntarily, my lord, she stated that she voluntarily accompanied the petitioner's matter to the.
Who is treating?
It's my second item,
It's specifically incriminated with specific allegations.
but against last six, perhaps, my lord, there is no.
There also.
He has a relation with classic. And let's see about the, see the major girl, madam. Not that she was taken forcefully.
The issue is not forceful, the issue is consent. Not forceful.
Yes, the offense was not committed, madam. As the offense was not committed.
No, it is apparent here.
So the matter is the next week. I think even some voters will be there. Will be checked.
You see the definition of 375. The statements clearly indicate. What is the state of the investigation? What have you done?
Investigation is going to be
No, going on means when are you going to complete? Or you'll allow the man to be released on default bail?
It is 90 days,
No. This, you'll have to change 90 days, so you'll seek for 75 days and then proceed on the investigation. That is not done. You have to give reasons why you want him for further detention. You get your updated CD on this. let the learned APP. APP is permitted to call for updated CD in respect of this. Matter be listed after reopening.
Almost 90 days. 30. Before 30 days, sorry, lost it from the-
Before vacation. 28.
My,
28.
other.
CD return.
Please step to item 42.
Why was it fixed?
Yesterday, order dated 35 lottery. I have connected the online order of center and page number 80. Around dollar 20.
Next date, oh, sir, you wanted the next date. 21/6.
Correct. And he is in custody. For personal yes. If there are any stringent condition may be imposed. For a clearance.
Why did you not file the pay there?
Only send the lordship petition was filed.
Yes, Mr.
My lord, here, Lordship, may kindly peruse the page 18, my lord. Order 30523, my lord.
What is the name of the petitioner?
Petitioner name is, my lord,
Jamal.
Tamal.
$1.
1, 2, 3, my lord. It appears from the case record that the accused person has been seeking time for appearance since 3/3/2003 and till that 4 adjournments have been granted. This part. My 23 till 4 adjournments have been granted for entering appearance of the accused person. Already 3 times has granted by the 4 adjournment. Hereafter, my lord, considering so, I am of the view that allowing further time to the accused person would delay the proceeding further. That case is proceeding for offense so and so. Person's name and action number. After NDW issue.
Once released, he will not appear.
My lord, only 4 adjournment.
He is a local person.
Maybe, but he will not appear.
And lordship, his 3 sons lordship is the same family member lordship and they are a pair, Tarzan and the customary lordship. But lordship and any condition lordship and 16.
I had learned counsel to the petitioner. This bail application is filed with the petitioner. As he is arrested and taken into judicial custody. By which order?
35 to the plan.
35
2023 NDW issue. My lord, warrant of arrest.
3005/2023. He was arrested pursuant to this order.
My lord, my lord.
He was
Yeah,
arrested.
sir.
Petitioner was arrested. Petitioner was arrested pursuant to NBW A issued by the order dated 3005/2023 by the court of CJL Gwalpara in PRC 1130 of 2019. So pursuant thereto, the petitioner was arrested and he has been in custody since then. The petitioner was produced before the competent courts on several dates, but his prayer for release of grant of bail has not been issued, not been accepted by the competent court. It is submitted by the learned counsel to the petitioner that the next date fixed in the matter is 21/06/2023. And the petitioner is a 63-year-old man. And he is a local person and therefore he is committed to appear before the trial court on each and every day as directed. Learned counsel to the petitioner submits that because of his illness, he could not appear. on 3005/2023, and because of which the competent court issued NBW. Mr. B. Sharma, learned APP submits that the petitioner was arrested because he failed to appear on 3 earlier occasions.
4 idea.
4 earlier occasions. Full stop. Perusal of the orders enclosed to the petition shows that the petitioner, although the petitioner did not appear, but the council appeared and steps had been taken. On 3005/23, the counsel for the petitioner appeared and submitted. Because of illness, he could not appear. However, no medical or supporting documents were presented, and because of which the competent board issued NBWA, and pursuant thereto he was arrested and taken into custody. Having heard learned counsels for the parties and on perusal of the pleadings available on the court, this court is of the view that for the ends of justice, since the ends of justice and considering the age of the petitioner and considering the age of the petitioner, the petitioner is directed to be released on bail. Upon furnishing a bail bond of rupees 30,000 to the satisfaction of CJM Walpara. Post of petitioner will appear before the competent court on each and every date, failing which the bail granted will stand rejected without any further reference to this court. Full stop. The petitioner will not move out of the jurisdiction of the district of Walpara without written permission of the competent court. Bail petition stands allowed, subject to fulfillment of the conditions as directed above. Dispose.
With your objection, please get to item 10.
Yes.
Well, before I begin, there is one mistake in the cost title. The father's name has been wrongly been typed. What you allow me, I will correct it by hand.
What is the name of the father?
It's Lolit Gogoi. Case name is the
In the name of the petitioner
in the name.
or the petitioner?
Hello?
Whose father's name?
By petitioner's father.
Petitioner's father. Okay.
But this is the real challenge. The manner the proceeding of a 145 proceeding has been drawn up and has been proceeded. And if you lordship find that enclose the order sheet, it contains 4 orders. And the manner the proceeding has been dealt by the activity masonry will be stopped. No, the procedure which has been prescribed by the 145 has not been followed. And the subject matter of challenge, the disposal order, the executive magistrate has gone beyond the power that is conferred. The lordship will kindly turn to page 15 of the orders.
50?
15.
Yes.
But the 5-4 the case record was received. Then notice was issued and 28th April was fixed for the date of April. 20th April both the parties present, both the parties were heard and fixed another date for hearing along with the Lakman on 29th April. 145(1) says, the parties has to be given opportunity to file their written statement. 29/4, both parties present today, both parties were heard. CO Themaji is requested to submit a verification on the report regarding the land before 5th of May. So, second party is absent. Now, the last order, 19/5. Second party is absent today, received report from CO Hogamo
and requested to deploy a mondal to demarcate the boundary as the case is disposed.
You are for whom?
I am for the second party,
First party,
second one.
second part,
Second one.
okay. So who filed this application?
It was filed by the first party, Junmuni Gopal, who is the respondent. In the,
Then why are you agreeing the case is dropped?
no, my lord, you actually find that. What is the direction, my lord? Request to deploy a mondal to demarcate the boundary. Now, the page 19 is the report, my lord, based on which this order was is been passed. Circle officers report,
19,
page 9.
yes,
Yeah.
yes.
Second paragraph, on verification, it is found that total 3 bigha 3 katha 12 mesa of land fall under revenue village, so and so. Of that said parcel of land, 1 katha 10 mesa is recorded in the name of June Gogoi through mutation by sale deed bearing registration number so and so. The land occupied by June Gogoi is free from encroachment at present. Now your lordship will find the page 21, the jawab. My name as a recorded pattadar, my father's name as a recorded pattadar has been ignored. So now by virtue of this direction, it is asked that the demarcation has to be done, and accordingly, based on this direction, page 25 letter has been issued to the circle office.
No. You see, the circle officers reported page 19 says June Gogoi's
June Gogoi,
property is, land is free from encumbrance.
free from encumbrance. So where is the question of 145 proceeding then?
But how does therefore it is, he has dropped it. Case is disposed and dropped.
Dropped with a direction. There is a direction
So
with the.
direction to deploy a mandal, how does it affect you?
My lord, because I am in possession of that land, and by virtue of this.
Say there.
Yeah.
Say there, you are agreed by the order of the circle officer,
I am agreed by the order of the circle.
the report of the
Report
circle
of the
officer.
circle officer as well as the order of the executive agency.
Your case is that there is some land under your occupation. Now circle officer says that this land is free from encumbrance,
The respondent's land is.
respondent land.
Yeah.
Which means that they have ignored your occupation.
My occupation. And now this order, the disposal order indicates that there has to be a demarcation of land. And by virtue of that demarcation, they are handing over possession to the respondent.
You are under illegal occupation.
No, I'm a recorded pattadar. You lordship will page 21, my lord. First name.
They heard Mr. V. Kaushik in constitutional petition, and this criminal petition is directed against the order dated
19/5/2020.
19/5/2022, passed by whom?
By the subdivisional rate.
Hmm.
Additional district magistrate.
Additional district magistrate. In
In case number 58M of 2020.
in case number 58M of 2020, under section 107, 145, 2021.
2020.
Learned counsel for the petitioner submits that the father of the petitioner is a reported pattadar, and in respect of the plot of land, details of which are enclosed in annexure 4, page 21. Also, the name of the father of the petitioner is Lolit Chandra Gogoi, and name is reflected. That's serial number 1, the name and addresses of the pattadars. These pattadars are joint pattadars in respect of the particulars of the land mentioned in the same Jamabundi. Also, learned counsel for the petitioner submits that the respondent had filed the case before the additional district magistrate, being case number so and so. And has managed to get an order seeking direction to the circle officer to demarcate the land. Also, subsequently, the petitioner has come to be, came to be aware that the said order was passed on the basis of a report issued by the circle officer, where a report issued by the circle officer, full stop, copy of the same report is enclosed as Annexure 3, page 19 of the criminal petition. As per the same report, the circle officer, after verification, has opined that the land covered by
Tag number 67, periodic patta 59.
tag number 67, covered by EP number 59, class Bari,
Revenue bill is going.
and revenue village Moinapara City, of which a parcel of land about 1 quota 10 lachas is recorded in the name of June Gogoi through mutation by sale deed having registration number 40 of 2019, dated 16/3/2019. Also, it is further opined that the said land is occupied by the said Sri June Gogoi within bracket respondent hearing, which is free from encroachment at present. On the same basis, on the same report, the Addition District Magistrate has passed the order impugned in the present petition also. Order dated 19/5/2022, passed impugned in the present petition. Let notice be issued returnable 4 weeks. Steps on respondent number, sole respondent by registered post within 1 week from today. In the meantime, the order dated 19/5/2022, passing case number 58 of 2021 by the additional district magistrate Bogamuk Dhemaji shall remain stayed till the next return of the date. Placed again on 17th July.
I will be allowed to correct the
Letter counsel for the petitioner submits that the name of the petitioner's father has been wrongly typed and correction to that effect is required. Learned counsel is permitted to correct it in the presence of the court master, and the court master will put necessary enforcement.
Unlisted item. Unlisted item, IA criminal 511/2023.
Case number is condition number 4. That is internal polymerase instead of Gori to case. Every way, Gori means the case number 8. Condition number 4.
Heard learned counsel for the petitioner, because I has been filed seeking correction of the order dated 9/6/2023, passed in AD number 2028 of 2023. Also by the same order, this court had granted interim bail to the petitioner on the conditions mentioned there. However, at clause Roman 4, the name of the police station was wrongly recorded as Kuliapur Police Station instead of Goripur Police Station. So the bail has been granted to the petitioner, interim bail has been granted to the petitioner in connection with Goripur PS case number 149 of 2023 under section 376 IPC. Also, in that view of the matter, the name of the police station stands corrected as Kozhikode Police Station instead of Koreagod Police Station at clause number Roman 4 in the order dated 9/6/2023, passed in AB 2028 of 2023. Also, para IA is accordingly disposed of. This order shall be read together with the order dated 9/6/2023, passed in AB 2028 of 2023. I stands disposed of.
State my lord, the lordship granted changes my lord some action. Changes my lord. Within 22nd, my lord, I will start
There's still time. 10 days from 99 will be 19.
from 96, my lord, 18 will complete.
Huh?
18 will complete.
18, there is still 2 days to go. Go report. Go and appeal. What is the difficulty? The petitioner is granted another 5 days extra day, 5 days extra, additionally 5 days more to appear before the IO as directed. All other conditions will remain the same.